rate of speed, the vehicle paced the vehicle at 102 miles per hour in a 65-mile zone and initiated a traffic stop. The driver and sole occupant identified as the defendant exhibited glassy eyes, slurred speech, and a strong odor of alcoholic beverage. Defendant consented to field sobriety test showing 4 out of 6 HGN, 5 out of 8 walk and turn, and 3 out of 4 one-leg stand. Defendant refused to answer when asked for a breath or blood specimen, which was treated as a refusal. An inventory of the vehicle revealed an open, closed to touch 333 milliliter truly unruly alcoholic beverage with remaining liquid and
Alcohol in the car.
and 2 cigarillo containing marijuana, 1 partially burned. A blood warrant was obtained and a sample was drawn at 4 a.m.
Okay. Does he have a license to drive it? Does he have any prior DWIs?
No priors, Judge.
He does have a license, Your Honor.
Mr. Scott, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs, including marijuana. You will be tested within the next 40 days. If you test positive for either alcohol or illegal drugs, I will put your butt in jail and I'm going to make your bond high. There will be no more PR bonds for you. I'm now placing an additional restriction on you. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, likewise into jail you go. We send notice to DPS in Austin so that every police officer in the state knows that they pull you over and that car you're driving doesn't have an interlock, they're going to take you to jail. Do you understand, sir?
Yes, sir.
License is eligible, Judge.
You are not allowed to drive unless you have valid liability insurance in your name as well, and that is also a condition. You have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. You know, I would venture a guess, with all the dying that happens on our streets in Harris County every single day, it's damn elementary that you're not to have alcohol in the car while you're driving, and it's a minimum of nearly a week in jail flat if it's proven in trial. Do you understand?
Yes, sir.
There are no mistakes in this life. There are choices. And the next boneheaded mistake may land you in custody for a very long time.
Yes. Thank you, Judge.
All right.
All right, Judge, next is Taco 6, Catalan.
Morning, sir. So you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On
right.
6/28/2026 in Harris County, Texas, officer was on patrol and noticed a car with registered expired registration since 2020. Upon initiating traffic stop, right passenger fled on foot. During the pursuit, defendant jumped fences and ditched a backpack he was carrying. Officer made contact with the defendant and attempted to enter the officer's vehicle. Defendant was detained, but provided incorrect name and partial date of birth. Defendant has an outstanding warrant for assault with a deadly weapon.
So did you say that he was driving? He was a passenger?
He was a passenger.
They pull over for,
Expired registration and he takes off.
so he just takes off on foot. Did they announce themselves saying that there were police and that to stop?
It doesn't say in the things from Gemini, you can, often say.
What time of day or night was this as well?
It doesn't say Judge. It doesn't say she announced. It just says it was a night shift. It doesn't give me a time.
Hey, have they put any devices on this dude?
Yes, ma'am.
Stop. I don't need your help, man. Really. You have the right to remain silent. Exercise that right. He's got 2 open aggravated assaults with a deadly weapon. He's now picked up and evading arrest. What kind of conditions have they placed in the felony court, if any? Please. Catalan.
In the felony court, these conditions have a GPS monitor with an exclusion zone. As well as the no contact with instrument.
Did they put on a curfew?
Yes, 9 PM to 6 AM.
All right. So let's tack on those conditions as well. Mr. Catalan, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you to remain under curfew from 9 PM to 6 AM and not to be in possession of any firearms. I'm going to protect my city at all costs. You have now 2 open aggravated assaults with a deadly weapon. You've picked up a 3rd case. You pick up a 4th case, or you violate conditions. I will deem you a public danger. I'm going to throw your ass in there, and I'm going to make you a very high bond. Heed this warning. You will not get another one. Do you understand? You are not to consume alcohol, illegal drugs, no contact with any of the co-defendants in any of the cases. Well, if there's a co-defendant in this case, there are people in the car, correct? I mean, if he's a passenger, there has to be at least one.
There is no other than the judge. Looks like it was the only.
Okay, no contact with any of the other cohorts? We will appoint you a lawyer. I'm going to appoint him a lawyer. I already have an affidavit on sign. I'm going to have you sign a reset, and then we will have you take a seat in the jury box, sir. Come on.
All right, Judge, next is page 10, Garabay.
Hey, are we going to trial today?
Yes, Judge.
Is she here?
Mr. Flood.
Sure, but are you trying the case? Do we have,
So Karina is gonna be in trial, but she said that she was sending somebody.
got, okay.
Bottom of 10, Judge.
If, we're just gonna pick the jury today.
Yeah, we'll just do just word hour today, and then we'll start tomorrow.
Yes,
Yeah.
yes.
This will fire today.
Just word hour today. As soon as we get done, have they,
He's going.
it's going now? Great. Okay, so as soon as we get done with this, then we get them, then we'll start. Yeah, just word hour today.
Thank you.
All right, you are Ms. Garabay? Ma'am, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On 6/29/2026, at approximately 15:02 officers responded to a hit and run crash near the 5900 block of Main Street, Harris County, Texas. Officers located the involved vehicles. CW stated she was stopped in traffic when the defendant's vehicle struck her rear bumper and then fled southbound without stopping. CW followed the defendant until police stopped it and positively identified defendant as the driver, stating she never lost sight of the fleeing vehicle. Officer observed damage to the defendant's rear bumper and hitch consistent with the impact. Defendant admitted being involved in the crash and leaving the scene, initially claiming confusion, but later admitted she fled because she did not have permission to drive the vehicle. Witness Salas reported seeing the defendant fail to slow down, strike CW, reverse, and flee.
Okay.
There is no criminal history.
Does she have a license to drive?
Um,
Ms. Garabay, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes.
These are your bond conditions. If you violate these conditions, a warrant will be issued. I will revoke your bond. There will be no more PR bonds for you, ma'am. Do you have the ability to hire a lawyer?
No, I need representation.
Okay, are you working at this time? Okay, we can have you fill out an application. I need to know everything about you, who you live with, any other household income, expenses, and then I'll take a look to see whether you qualify. Don't leave anything blank and don't put zeros. Otherwise, I'm just going to send it right back to you. Okay, please, ma'am. Do not leave until you sign our bond conditions as well. Thanks.
My driver's license was eligible, Judge.
Okay, great. Can you file no driving without a license or insurance, please?
All right, Judge, top of 14, Jones, come on up.
Good morning, Ms. Jones. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On June 26th, officer responded to 2222 West Creek Lane in Harris County, Texas, for disturbance. The complaining witness stated that she and defendant have been in a dating relationship for about 1 year. The complaining witness said that after both arrived at the apartment, he approached her while she was charging her phone and, still upset from an early argument, struck her on the left side of her head with a closed fist, causing immediate pain and visible to knot above her left elbow. Above her left eyebrow. TW stated the complaining witness stated that she pushed defendant away and a brief struggle occurred before a friend of defendant's forced her out of the apartment. Officer observed swelling consistent with her statement, and the complaining witness possibly identified the defendant as the person who struck her and wished to pursue charges. The defendant was identified by her Texas driver's license.
Okay. Hey, Farwa, can you do an NCIC on Ms. Jones? Does she have an open DWI in another state?
Yes, Judge, I'll write it right now.
Please. Ms. Jones, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person and not to be in possession of any weapons. There's a protective order that has been issued in this case, and you need to get to know it. If you violate the protective order, they can file an additional case against you, and a violation of protective order is one of the worst cases you can pick up. Do you understand, ma'am? We're going to reset your case to give you time to hire a lawyer. For now, I'm going to have you take a seat. We're going to verify if you have an open case in another state, and we will take the appropriate measures at that time. If you do, I'm going to have you sign a reset. We will have you take a seat in the jury box. Do not leave until you sign the bond conditions, ma'am. Please.
Top of 17, Martinez, first initial G. Around.
Victoria, what? You say top 17?
Yes.
Good morning, Mr. Martinez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay,
On June 28th, 2026, in Harris County, Texas, officer was dispatched to a welfare check. Someone was asleep behind the wheel at a traffic stop on a public roadway. Upon getting there, officer observed the driver hunched over to the side of the driver's seat and observed a vehicle between lane 1 and 2 with an open container of Coors Light beer. Officer also observed a glassy eyes, strong odor of alcoholic breath, and sweat from the defendant. The defendant stated he had 2 beers. The SFCs were 6 out of 6 on the HGM, 5 out of 8 on the walk and turn, and 3 out of 4 on the one leg stand. And then VIC was red, and he blew a 0.115 and a 0.115.
okay. Any prior DPIs? Can you tell?
He has a prior DWI, you said?
Does he have a prior DPI from anywhere else?
It doesn't look like it.
Mr. Martinez, I'm going to find that or does he have a license to drive?
I can't check it.
Do you mind forward checking? Mr. Martinez? I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. I'm now also putting an additional restriction on you that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. There will be no more PR bonds for you. This is not a revolving door. Do you understand, Mr. Martinez? I don't know you, but if you have a problem with drugs or alcohol, you better address it, because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not to like the way that I do it. Do you understand?
It was eligible.
It's eligible. Okay. We are going to reset your case to give you time to hire a lawyer. So I'll have you sign a reset. I'm going to have you take a seat in the jury box till we get your bond conditions ready. Once you sign them, at that point, you'll be free to go.
All right, Judge, top of second column, come on up.
Do you have an arraignment?
I do, Judge.
You ready?
She's so on top of it, she did it once. I'm ready.
Happy Monday.
Happy.
Yeah. Monday it is. You said talent?
COLLUM. I don't know exactly.
I see it. Okay. All right. Mr. Collum, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On June 28th, 2026, at 1:51 in the morning, officer responded to 499 Webster Street in Harris County, Texas for a major crash. The complaining witness stated he was traveling eastbound with a green light when the defendant ran the red light and struck the left side of his vehicle. The complaining witness saw the defendant exit the driver's door to strike the vehicle and flee on foot. Bystander stopped the defendant nearby. Upon contact, officer observed defendant to have red glossy eyes, strong odor of alcohol, slurred speech, and difficulty following instructions and troubled standing. While officer questioned him, defendant attempted to walk away. Officer threatened his sweat and detained him.
Say that again?
He attempted to walk away and the officers
Detained him. Okay.
SFSBs were attempted and defendant exhibited 6 out of 6 on the HGM and was too intoxicated to safely complete the walking turn or the one night stand. The defendant consented to a blood draw at 3:55 in the morning.
Okay.
With no criminal history.
Prior DWIs?
There's no criminal history.
Mr. Collum, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using either, including marijuana, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand, sir? Because you have a lawyer, I will waive your appearance. It's not, you don't have to waste your time coming to court, but you must stay in touch with them. If they tell you that you got to come in, then you have to come in. You will be called to take a test. It's just a matter of time. It's not a matter of if, it's when. If you fail to show up, likewise, a warrant will issue. Do you understand?
Yes, sir.
All right, we'll have you sign a reset conditions, then you're on your way. Please.
All right, Judge, next is page 21, Ramos.
September first. August 31st.
You are Ms. Ramos. Ms. Ramos, you're charged with two cases. You're charged with driving while intoxicated and failure to stop and give information. On both of those, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can, oh, got a third case and a felony PCS. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On June 27th, 2026, at a minute after midnight, officer responded to assistant off-duty HPD officer at 8600 Memorial Drive. Complaining witness / off-duty officer stated that he was involved in a FSGI at I-10 Service Road at Silver Road. When a gray Nissan driven by defendant's truck, his vehicle and flash. The complaining witness followed the vehicle into a neighborhood and notified dispatch. The estimated damage was at $2,000. Officers located the vehicle at 329 Buckingham Drive, conducted a felony stop and detained B as she exited the driver's seat. The complaining witness possibly identified the defendant as the driver. During contact, the officer observed the defendant to have glassy eyes, an odor of alcohol, and then SFSDs were 2 out of 6 for the HGN, 5 out of 8 for the walking turn, and 4 out of 4 for the one-night stand. The defendant was transported to JPC where she refused breath and blood samples. Blood work was obtained and the sample was drawn at 4:12 in the morning. When inventorying the defendant's property, the officer located a small plastic bag containing crystal-like substance. Based on packaging, texture, appearance, and training, and after confirmation by narcotics personnel, the substance was identified as 0.23 grams of methamphetamine, a usable amount.
Got it. Okay. Ms. Ramos, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. There'll be no more PR bonds for you. You understand, ma'am? Does she have a license and any prior DPIs? Or can you check that?
I have to, she's one that was dismissed, but not.
Oh, you see a DWI dismissed?
Yeah. I don't know.
As a condition of your bond, you're ordered not to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, then likewise, you will go to jail. You understand? You will be tested randomly and a lot. Do not use. If you have a problem, now is the time for you to address it. Otherwise, it's just not going to go well between us. There'll be no further warnings. Do you have the ability to hire a lawyer? Right, how do you support yourself? Okay, it's time to get a job. Do you understand? Okay, see if I have an application on the file. If you'd like, you can apply for a court-appointed lawyer. Debbie will give you an application. I need you to fill it out, and then we'll take a look to see whether you qualify. Do not leave it blank and do not put zeros. All right? Okay, please.
All right, top of 26, Cifuentes. Come on up. Go ahead and sign Cifuentes.
Hey, Vic. Victoria. All right, you are Mr. Cifuentes. Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 29th, 2026, officers dispatched to a crash on Long Drive in Harris County, Texas. Officer observed defendant's vehicle to be idling in a drive-through with Jack in the Box. The wheel witness stated he observed defendant's vehicle idling near the drive-through directly behind another vehicle that was parked in front of the drive-through window. Witness approached the driver's side door of defendant's vehicle and observed defendant to be the only occupant. With the state if he opened the door and observed defendant to be in the driver's seat with the vehicle on and accused of ignition. While speaking to the defendant, officer observed defendant to have bloodshot glossy eyes, slurred speech, and a mild odor of alcoholic beverage coming from his breath and person. Student field sobriety tests were conducted, 4 out of 6 HGNs, 6 out of 8 walking turn, and 3 out of 4 one-leg stand. Defendant provided a threat sample, result for 0.158 and 163.
But what brought them to the car? I didn't hear you say it. I know that he's at a drive-through. Was he asleep
It
at
was
the
a
drive-through?
crash and minor disturbance. Defendant was just idling in the drive-through.
Was he involved in the crash?
I don't know if there was a crash. It looks like it was just a disturbance. But the real witness supported defendant to be idling in the drive-through lane, I believe not moving.
Wow. Right? I let the drive-through all the time too. What has he done wrong?
Looking at the ginger now, Your Honor. From my reading of the Sims, I believe he was in the drive-through not moving, and so the witness came to approach.
You didn't say that though.
Well, it stated that the vehicle was idling, and then the witness came to the driver, to the defendant's vehicle.
You're making assumptions though. I mean, yeah, someone came up to him, right? Maybe, but it doesn't say that he was there. All right, Mr. Cifuentes, I want to find there's no probable cause to go forward with your case. Be careful, sir. All right? Come on.
All right, Judge, right below that one.
Scobla, coming up. Oh, hey, good morning. Have you signed on already? I didn't see that you were.
I initially filed this morning.
Great. So before you leave, make sure, okay?
Yeah.
Okay, it's fine.
But not all problem.
Yeah, for sure. Got it. All right, good morning, sir. Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
From June 24th, 2026, officer responded to the minor crash on FM 2920 in Tomball, Harris County, Texas. Officer and a witness identified defendant as the driver and sole occupant of the vehicle that struck their vehicle. Complaint stated an individual saw the defendant discard an open bottle of liquor, and officers located the open container of gin in the parking lot. Defendant admitted to drinking 3 beers earlier at the bar and stated he had not been since approximately 1600 hours. Defendant exhibited signs of intoxication. And the standard field sobriety tests were conducted, 6 out of 8 HPN, 2 out of 8 walking turn, and 2 out of 4 one-leg stand. After being read the VIP, defendant consented to a breath sample, and results were 0.189 and 0.182.
Are you telling me that he was consuming or had an open container
Yes, Your Honor.
in the car?
Well, I think the problem comes with the bottle thing, to the cards, be clear whether it was over here.
The officers located an open container of the chips in the parking lot.
Does he have any prior DWI?
No prior, Your Honor.
Mr. Scoble, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I will revoke your bond. You understand, sir?
Yes.
Okay, as a condition of your bond for the moment, I am going to put an interlock on your car. Okay, if at the time we have no issues, then we can talk about it, but really, I'm not asking much. I want my streets safe and I'm going to do everything in my power to protect you. Do you understand? Really, I'm not asking you to split the atom or anyone to do anything nuts here. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. For now, we'll have you sign a reset. You'll get with pre-trial for your bond conditions and you're free to go. Please.
Judge, I think she's got a panel in order.
Oh, hold on.
It's not an arraignment, Judge, so I.
Talking, but do you really have a panel waiting?
Yes.
Okay, talk to me. It's great. Yeah, of
I
course.
have Katie texting me a red light just in case.
No, don't worry about
Sorry.
it. Talk to me.
I have Jonathan Madrigal. He has a bond violation. It is a first bond violation. There are 10 skip tests. After looking over the report, it seems like 6 out of the 10, I'm getting these numbers wrong. 6 out of the 10 are the super, super late at night ones. But the majority, he's doing the following below. So it's not like he's ever skipped an entire day or anything like that. I just thought I'd bring that to your attention.
So here's what we'll do. We'll put a scram on him right now. Any further violations, and he'll stay with me.
Understood, Judge. And then also, I have a trial set in here tomorrow. Can I get a new date on that? Since
Why?
well, one that you guys are going to
Yes.
start trial today, and then I'm also starting trial upstairs.
So, yes,
Okay.
but I want to make sure that everything stays. If you're actually in trial, then obviously. If we in trial, obviously, right?
Okay. Just like, yes, Judge, we are in trial. Are you guys, what is y'all's trial schedule? Are y'all thinking during today,
And then start tomorrow.
starting tomorrow?
I guess, yeah. Go
Okay,
ahead.
thank you, Judge.
Good luck.
Bottom of 28, South 29, Oliver, come on up.
Around the other way. Hey. Victoria, do you need Scobla back up here to sign?
Right, Judge.
Scobla, come up.
Go ahead and sign for your receipt.
You're Mr. Tolliver. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Looks like you're also charged with theft. On that one, you're also facing up to 6 months in jail. Like I said, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On June 5th, 2026, deputy responded to a Walgreens at 388 Uvalde Road in Houston, Harris County for a disturbance. The complaining witness and manager stated defendant previously trespassed and was arrested for robbery at the same location. The defendant entered the store, took a case of beer valued at $17.88 without paying. The complaining witness possibly identified the defendant from prior dealings in the booking photo. A criminal history check showed he was previously convicted of theft from person on April 6, 2026, involving the same location, and the complaining witness wants to pursue charges.
Right, Mr. Tolliver, as a condition of your bond, you're ordered not to go back to this location, not to have any contact with the complaining witness in this case. Do you understand? I don't know who you have in this life, Mr. Tolliver, but if I have to revoke your bond and make him each $10,000 and you don't have anyone to pony up that money, you will be stuck like Chuck with me for who knows how long. You understand me? You are ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, then likewise, you will go to jail. How do you support yourself, sir? We are going to give you time to hire a lawyer. It's time for you to get a job. When is the last time that you had a job? I'm going to bring you back in 2 weeks, and I want to see what you have done to get a job. If you have done nothing, it's not going to go well between us. Do you understand me? True, that is not an answer. I am not your friend. This is a court, and we speak a certain way. Do you understand? Come on.
South of 27, the sign is just.
Hey, Veronica, no weapons, please.
All right, go ahead and sign. Roll call.
Sokolov. Ms. Sokolov, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On June 25th, 2026, deputies responded to 24236 Northwest Freeway in Harris County, Texas, regarding a suspicious vehicle unable to maintain a single lane. Deputy observed a blue Dodge Avenger failing to maintain one lane and.
Hold on. Hey, stop. Go ahead,
We
please.
noticed the Avenger failing to maintain one lane and making a wide left turn using two lanes before conducting a traffic stop. The driver identified by Texas identification and the defendant exhibited strong slurred speech and stated that she had taken two 300 milligram gabapentin pills 2 hours prior. The HGM was not conducted due to a documented eye condition, but the walking turn had 4 to 8 clues and the one next stand showed 4 to 4 clues. Based on signs of intoxication and the SFSDs that were performed, deputies determined that defendant had lost normal mental and physical facilities. Defendant initially agreed to provide a blood specimen, but later refused at JTC. A warrant was obtained and executed.
Does she have any priority of the eyes?
I am not beating them.
Hey, Farla, can you do it? This is Ms. Sokolov. Can you do a dive on it and see if she has any priority to the eyes, please?
Yes, Judge.
I'm saying that it was written in the case check that her driver's license was not eligible. I have extended, there might be some,
So it's not eligible.
not eligible.
Ms. Sokolov, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. You are not allowed to drive. You do not have a valid Texas driver license. I don't give a rat's behind what you have to do in this life. You will be signing an affidavit with me today. This is a promise that you're going to make to me that you're not going to drive. I don't care that you have kids. I don't care that you have to go to school. I don't care that you need groceries. Nothing can be justified for you getting into a car and driving. Do you understand?
Yes.
Every time you drive, it's an offense in and of itself, and I can hold you in contempt, slap you with 180 days and a $500 fine every single time. Do not drive. Do you understand?
Yes.
If you want to drive, you need a license and insurance, and then we can talk about it. But until that point, if I find that you're driving, you have the ability to hire a lawyer, ma'am.
No, Your
How do you support yourself?
I just currently lost my job trying to wait and get my car out of it. After getting put in jail.
Okay, we will have you apply for a court-appointed lawyer. Ms. Sokolov, I don't know who you have in this life, but if I have to put you in jail and make your bond high and you don't have anyone to put that kind of money up, it's a long stay. Do you understand? All right, so we'll have you sign. We'll get you sign a reset in bond conditions, and then we'll take a look at the application.
The last one, bottom of 20.
Hallelujah.
Top of 30.
Vasquez, come on up.
Yes.
So she's on bond for a case and she's now picked up a new case. Ms. Vasquez, you now stand charged with violation of a protective order bond condition. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 28th, 2026, in Harris County, Texas, officer dispatched to a disturbance and unknown weapon call. The complainant witness stated his ex-girlfriend defendant came over despite him telling her not to. They did not live together, but the complaining witness stated that he was going to try to pick the defendant up the day after this occurred. But the complaining witness stated that the defendant got an Uber and headed to the complaining witness's residence despite being told not to. When the defendant arrived, the complaining witness stated she was clearly drunk, and although no one was assaulted, the complaining witness stated he had called because the defendant's personality is different when she is drunk. The officer observed the defendant walk out of the complaining witness' residence, and there was a bond condition that they were not supposed to have any contact.
The only thing I ordered you not to do is pick up a new case. Now you've picked up a new case. I am now going to revoke your bond and you will go to jail. She goes with you. Hey, do you mind appointing her a lawyer, please? Well, I'm gonna talk through with your lawyer and then we'll figure it out. But for now, you're remanded. Hey,
There you go. Coach on Mr. March.
Ms. Lewis, I'll hit you up next.
Thank you, Your Honor.
She is Velasquez. He's on PTI for,
Is he here?
he's here. He's been on PTI for 10 months.
He's out.
I want to see if there's any way I can get like 2 weeks to appeal it because.
I'm not doing 2 weeks. It's 600 days old. I mean, I'll give you up until the end of the week. You know, get it done now.
See what we can do.
Right, but if by the end of the, and what are the violations?
A lot of skip tests. He's completed his classes, but he's had excessive skips from his classes.
But you never tested positive, never know why.
Yeah, because he's not
Well,
testing.
no, I understand. But when he does, there's no violation.
That's the reason why it's not when you choose, it's.
And if he had not been on it for 10 months, 10 out of 12 months.
So we'll set you to Thursday,
Okay.
try to have a decision by Thursday. Karina will be able to make that decision for you. She's just in trial now, so,
Okay.
yeah, okay. All
Yeah,
right,
thank you. Appreciate it.
you got it. Ms. Lewis,
Good morning, Judge.
hey,
I'm here on Nicholas Rogers.
Rogers.
Yes.
Okay, so is Mr. Rogers here?
He is, Your Honor.
Have you guys decided what you want to do?
Well, the last time we were there, Your Honor, I had approached on Zoom because we were in the middle of a capital murder. And you
Sure.
set it for today because he wasn't at the last setting. We just got out of trial on Thursday, so I hadn't had an opportunity to talk to him. So I was just going to ask the court if you can set it till Friday to give us the opportunity to get a
I'll set it for
decision on
Thursday.
things.
Friday's an arraignment day for us, so how about
Oh, okay.
Thursday?
That works, Your Honor.
Okay. Hey, Barwa, can you help me out? Are you running the names? I don't know how much he can do, you know, that's the problem. On Rogers, is there an offer? Please. Do you have an offer on the case?
I believe we do have an offer, Your Honor. We just hadn't had the time to sit down with him because we were preparing. for that.
Rogers, come up. Around this way, please.
Your Honor, we can confirm there is.
There is an offer. Discovery's complete.
Mhm.
Maybe can do some surveillance video.
It's not gonna happen. It's 200 days. If it's not here, it's not gonna happen. Mr. Rogers, your case is 201 days old. It is time for you to make a decision on what you want to do with this case. You will be back here Thursday. It would probably be a good idea to meet with your lawyers and decide what you want to do. But on that day, you must either accept the plea bargain agreement or I will set your case for trial. If we set the case for trial, you will go to trial. There will be no more plea bargain. That is your deadline. Do you understand? Okay. All right. We'll have you sign a reset. We'll get you out.
Judge, you said Thursday?
Yeah. Okay.
Thank
Thank
you, Your Honor.
you.
Have a great day.
See you then. Have fun.
This way.
Why see it in? You see? Yeah.
I'll hit you up next, Russ.
Good.
You were Mr. Abercrombie? Mr. Abercrombie, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 36 days in jail. You know how much credit he had? With 12 days of the credit that you have already earned, you were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you were not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is final today. You can never change this or undo this. It will go on your record from now on. It's a minimum of 30 days in jail. Do you understand?
Yes, sir.
Is this what you want to do? If you are on probation or parole, this can be used against you, resulting in further confinement. Knowing all that, you still want to do this, sir?
Yes, sir.
How do you plead to the criminal trespass?
Guilty. Guilty.
I'm going to find you guilty. I'll follow the agreement, send you to it. Good luck to you, Mr. Abercrombie. All right, Russell, you ready?
Yes, sir. I have I have a bond I wanted to get on someone. I brought him in the bonding company. So can I bring him in? You give me the call.
You ready for case number?
Yes, Judge.
What is it?
22494. It's a Chris Saldana.
So 2622494?
You need a PSR.
I'll done.
Yeah.
He's here going to bring them.
Give me 1 second.
Okay.
Veronica, did you hear that?
Yes, I've been looking at this read it first night.
You got the cause number though?
Yes.
I can step out there.
Yeah, you want to grab
Do I just approach the notes?
it? Go. We're waiting on you.
Oh.
Go. Move like the wind, man.
15?
Hey, Mr. Baez.
Yes, sir.
Hey, man.
Morning, Judge. How are you?
What's up? Who you here on?
Judge, I'm here on Mr. Casco Ramirez.
The last name is Castro?
It should be CASCO. Ramirez might be first. It might be Ramirez Casco.
Did you get that?
Yes, Your Honor.
What's the last name?
Ramirez. As a caution receipt.
I see it. Okay, you just want to reset?
Yes, sir.
It's all right.
Judge, how is August 18th to the 20th?
The 18th is great.
Okay, we'll give it to you.
Thank you, Judge.
Have fun.
Yes, sir. You too. Thank you, Judge.
Russell, you ready? Come on. Go around this way, around this way.
Do you want me in the middle?
Dealer's choice.
Okay. We're going to discuss situation. Just like,
Mr. Aldana, you're charged with assault causing bodily injury. You're facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Speak English?
Read out evidence on the phone order.
Okay.
On October 30th, 2025, complainant stated he,
Is it too deep?
complainant stated he and the witness exchanged phone numbers after he stated she wanted to use his Uber services to travel to and from downtown area. Complainant stated one day the witness texted him and asked him for a ride and informed her that he's not in town. Complainant received a message from the witness's phone number and asked him to meet her at a location. Complainant stated he then received another text from the witness who informed him to meet her at a location. Complainant arrived at the location, exited his vehicle, and noticed the defendant approach him, and that was when the defendant punched him in the face with his fist. Complainant stated he grabbed his face and walked to the vehicle, and that was when the defendant informed him he needs to no longer reach out to the witness.
So he's the Uber driver.
So it looks like the complainant was talking to the defendant's girlfriend. And
Well, so the complainant is the Uber driver.
No. I think the transaction started rather than the text. Is that
Yes.
correct?
So the complainant stated he and the witness exchanged phone numbers after she stated she wanted to use his Uber services to travel to and from. And Your Honor, this is from the defense.
Now
yeah.
I'm also confused. Who is the driver?
But it looks like the complainant and defendant's girlfriend were contacting each other, and then the defendant's girlfriend asked him, complainant's girlfriend texted him to meet at a location, which is when, and the complainant arrived at the location, and the defendant was there and, assaulted him.
So what does he have to do with anything?
So the defendant is the witness's boyfriend, and the witness is the one who reached out to the defendant to come to that location.
Got it. Okay. Mr. Aldana, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to have any contact with the complaining witness in this case and not to be in possession of any weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. There'll be no more PR bonds for you. Do you understand? You already have now number 2. If you pick up a third case, I'm going to deem you a public danger and it will not go well between us. Do you understand? You are not to be in possession of any weapons as well. All right, we were going to have you sign a reset. Or we need to set a bond. So what do you want?
PR two,
I'm not, he has an open family violence.
2,500.
What do you think?
5,000, Your Honor, he picked up.
Okay, I'll split the puppy.
Hmm?
This is not a revolving door. We will not do PR bond after PR bond after PR bond. Do you understand, Mr. Aldana? Okay, so the bond's at 3,750,
Yes,
give or take.
yeah,
Um,
I think 3,500 would be easier for everyone to.
Sure. Okay, I'm down. We'll do that. So bond is set at 3,500. Understand? Really, you're skirting thin ice. You understand, Mr. Aldana? All right, come on.
Thank you, sir.
All right, so he'll be monitored with patrol.
Bond conditions? What
Yeah.
about, is it a PR bond or?
No, it's a surety bond at 3,500. Yeah, he's gonna have to, they have a bonding company here. Justin, hey,
On Mr. Lorosky, he sent a document to got last week.
I don't remember what I had for breakfast,
I
man.
understand. I can give you the case number if you'd like it.
Okay, please.
It's 261-9462.
Give me 1 second before I forget. Let me do this real quick. Okay, so 261.
9462. To Paresh Lorosky.
I remember the place.
They talked to the complainant, confirmed she does not live at that address anymore. We're not
Okay.
asking that they be able to have
You're good?
contact.
Great.
I'm not asking that he be able. to-
Yeah, I'm okay with it.
Just want
Yeah.
to take that address out.
Done. But there is no contact with the complaining witness, right?
Yes, sir. No.
Okay, so for some reason, this was marked out on the protective order. I'm going to put it back on the protective order. He's not to have contact with the complaining witness, but I will mark out the address.
We thought there was no contact in the first, he's been operating that way. And that doesn't start the protective order period over again.
No.
Okay.
no.
Okay, that's all we did. Thank you.
So just for that, take it. Okay. Mr. Wong, is, hey, is the jury here? They're ready? Okay. All right, come on, talk to me.
ULLOA.
Uloa,
ULLOA.
Okay.
James. We have on probation on.
oh, is he in jail?
He can do it.
Judge, he was placed on a 6-month probation back in 2024. He tested positive for cocaine. He brought him for a court admonishment. He felt severe. He has been absconded since then.
He picked up a new case in June?
Just picked up another receipt.
We try to help people. We bring them in for a court admonishment in hopes that we can try to put them on the straight and narrow path so that we can, we notice that he's testing positive. We try to bring him in to perhaps amend conditions to put them in a better manner. And he just took off on us. Not only did he abscond, but he picked up a new case as well. I just don't think it's a good idea, but I don't know what we should do. So can we maybe roll to tomorrow, the next day? So we can kind of get it. Have you done a TRAS lately?
No, sir. He's been gone since 2020.
Yeah, I just don't think it's probably a good idea. But I see what you guys can work out. We can go from there. So we can resolve everything.
Understood.
Yeah, okay.
And Your Honor, for transparency, it looks like new UCW charges in two people. Not in state 2023 from before he was gone.
Oh, interesting. Okay. I don't know what, perhaps you're gonna put an offer, maybe we can work some kind of global,
Yes.
you know, Justin.
There's pre-trial caught that on this too. There's a,
He has the bond condition declaration address.
Okay, we'll take it off. Yeah,
Can you wait the signature on that?
yes, of course. Mr. Ligon,
Hey, good morning, Judge.
hey bud, talk to me.
Yes, sir. I just have a quick motion to sub I need you to sign on Mr. Ricardo Mejia Sanchez. I have a cause number if you need it.
Yeah, you guys ready? Okay, what is it?
261-8848.
When's it on docket?
July 15th.
Okay, we'll leave it. Is it an old case or is it a new case?
It's a new case filed on May 7th.
Got it. Okay, I guess we'll just leave it on that day, then we can talk about a new one on, you know, when you come back, huh?
Yeah. I was just told I needed to get you to sign on the
Yes.
motion to sub.
Yep,
so-
we'll do it now. I'll sign
Okay.
it here momentarily.
That's it. That's all I got, Judge. Thank you. Have a
Thanks.
great day.
You too, take care. Herman.
I have two on dockets real quick. One is set for trial, you're not gonna be happy. Can I get the cause number real quick?
Sure.
Wants to do.
Thanks for being honest.
Yeah, well, yeah, I mean.
Well, what's the cause number?
With the 258-9003.
Okay,
He's requesting, I think he's an automatic, it's just a 109. And he can do the walkthrough today,
he's requesting what?
PT9.
Is this case up for trial?
Yes, sir,
Why?
because he decided to trial and now he's changing minds.
No.
I mean, he's here if you want to tell us.
No, I'm not. I have a jury waiting now. No, we're set. We're going.
Okay, and then,
It's not the case that we want.
I know. I get it.
it's, yeah,
I understand.
Another one, I'm just trying to amend, he starts work, he leaves his house at 4 o'clock to get to Beaumont, 4 o'clock in the morning.
Okay.
Just wanted to make conditions.
What do you, okay.
A different case.
I know. I remember your guy. Did you want to do amend it something else?
No, he's now asking if we can amend it so he can leave his house at 4 AM.
What is he leaving it now?
I can't do it, I would like around 6. So if we can just amend his conditions.
I need to do a deeper dive, Herman, to see,
Okay,
I mean, obviously for job.
yeah, it's for his job.
What's your cause number on that?
262-4148.
Okay.
So I'm just trying to get to the point because I know there's a panel.
Just make sure that there have been no problems with pretrial. If none, then I'm okay with that. Yeah. I'm okay with it, assuming there's no issues with pretrial. Yeah. Hey, ready?
Yes, sir.
We gotta hurry because I got a jury waiting. I need to bring him in.
You can do anything.
Who do you got?
I have a few, Your Honor. I got Miss Garibay, Gariba.
Is that's a new case, right? Yeah, we're done.
And then I got another one, you told him to hire from Mr. Blake, he just hired me, so I went ahead and filed my notice of appearance. He hasn't, otherwise, if basically that's, I think he's already seen you, probably got bond.
Okay, yeah, done.
Here you go.
Go,
Thank you.
go. I seen it. Talk to me real quick.
Fast, Dinesh, his last name, Milan.
Is it on bond today or on docket today?
It's a fugitive case where you didn't know he had a Pensacola case, so they have bonds out there. We got an attorney, this kid is 19, no criminal history, it's a civil case, he sells. Anyway, he's going to the Caribbeans on Thursday and they're taking him, so can we get a bond set?
You need to talk with Day because there's a specific division that deals with fugitive cases. So, you know, Mr. Ken,
Oh, yeah.
you know Day?
Yeah, he used to be a misdemeanor prosecutor, is he?
I mean, it's been a long time,
Yeah, so
actually.
he's the fugitive, so the state has to agree to a bond essentially, or?
Well, no. We go through a whole spiel and dog and pony show to see whether we should. Has he been given a fugitive bond before? How dangerous is he? Does he have a lot of priors? So the whole,
I got you. So talk to Dave and
I'm texting him right now that we need you. So what's the last name again? Dinesh?
He's on document. So I can roll him till tomorrow, I guess, and then.
Give me a second. Let me see how soon we can get him down here.
Okay, awesome, thank you. You about to start a trial?
Yeah.
Yeah, you might want to check with Victoria, make sure she didn't appoint him an attorney.
No, we're in touch. Thank you. It's actually off.
Okay.
Thank you.
Okay. Hey, can we get the jury? Are we ready? Need to clear. Yeah. Hi, Joe.
Morning.
Hey, what do you want to do?
Could I wait around until after the hearing and take a sleep?
Yeah.
Okay, I'll be going.
Why don't you start working everything, get everything done? And
That's what I'm doing.
we'll take a small break in between so I can get you out. So
Thank
you don't have to wait the whole time. Hey, the sooner you're ready, Joe, the sooner we'll get it done, really.
It's up to them.
Hey, Cena, if you want me to, we can. It's not a big deal. If you want to roll till tomorrow, we can. No. I will tell him, and we do resets for him, but she doesn't handle the resets. Jay does. But I will tell him. Yeah, last name. No. I'm giving you, so it's, let me give you sticky. So you know who to deal with. You know who. Okay. So reach out. No.
Perfect.
That's it.
Okay, I'll email him and then, see how it goes.
If you guys can agree on a bond, great. If not, then we'll go through the whole thing and there's a bunch of stuff that I need to see. We'll see. Yeah, of course. Let me get Mr. Flood. Got it.
Oh, it's a family, I don't know if it's.
Yeah, you did. That's okay. Thanks. Oh, great, you're here, Tyler. So who's trying it? You're doing Bordar?
Yes, sir.
Okay,
I had a.
great to see you, man. How are you? How are things?
Doing good. It's kind of hard to get
You
started.
look good, man.
Sorry.
You look good. You look great.
Appreciate it.
Yeah.
Still healing from my necrotizing fasciitis.
Shut the front door. You really,
Yeah, I drilled through my hand and had to have like emergency surgery.
no. But how did you develop the necrotizing fasciitis?
Because I'm already doing DIY projects, and I was drilling into a board that like had some grain mold on it, and the drill slipped off of the screw and like went through my hand. And then my arm started bleeding out, and they're like, you need to go to the medical center.
Dude, that's some crazy, necrotizing. You look literally lose.
That's what they said. If I would have done that, I would have lost.
Oh, it died. That's those brown recluses, man.
Within hours. It's only an infection, like the next few days, it'll get red. It was like immediate. I never had to look at skin crap on there.
Dude, I'm glad that you did what you did, man. You're smart because scary stuff, huh, Ramona? I mean.
Yeah, look, I'm sitting here going.
I see you backing away. Yeah. They scoop it out. Yeah, that's just crazy. Yeah, I'm glad you're okay, man. That's just.
Me too.
Yeah. Imagine how, I'm gonna be like bionic and shit. Yeah, you go, bro. Kick Captain Hook. It's not a, it's really not a lack of man.
There were,
Are you ready?
3 issues.
Yeah.
Slides that we're gonna show.
Oh, hold on. Have you seen the slides or no?
I've seen the slides, I've already made it, I've discussed it with them, and I said we present it to you, however you will.
Oh, okay, so we need to go on the record and do it then.
Just, we filed a motion for community supervision.
Okay. Hey,
When we're coming to court for punishment.
Ramona, are you ready to go on the record by chance?
Right here, the state's not quite ready.
Or are you trying this case?
No, yeah, you have something.
Judge, I have a couple answers. Do you mind if they sit in the jury box?
No, of course not. Do you, hey, do you have any objections to the slides? So they have some objections to your slides.
Yes, Judge, I'll be right there.
Okay.
We've spoken about that.
We need to, I'm gonna get you guys up. We need to make announcements.
Okay, you want me to go there or?
No, just stay right. You're cool. Well, hold on. Let's get on the record first before we.
No, I was just letting you know, Anthony Esparza is coming in to fill in for,
Karina,
Karina, yeah.
when?
I
Because we're gonna start now, though.
Here right now.
Yeah, we're starting. We can't wait. The jury's been out there for at least 30 minutes. I don't want to keep them waiting. Joe, did you get filed or no?
Oh, I don't know. She was doing it.
You know what? Hey, maybe ask Farwa in back. We have a DA in back. You can ask her to file it too. Maybe faster. But you need a translator too.
Yes. So I'm not in a hurry. After you pick a jury, if you like, it's up to the judge.
Okay.
She says she's doing it.
I'm doing it right now.
Okay, all right. You wanna, hey, ask, Victoria for a translator. That's okay. Take a look.
Oh.
Just wait now. All right, for the jury.
Just hold on. Give me 2 minutes. Yeah, sorry. It's okay. Hey, you guys, come on up.
It's a joke.
Judge, I don't know who you think's briefcase.
Yeah, just.
Right, once they should be.
There's not enough DAs, man.
Huh?
We don't have enough DAs.
And,
I'll meet you then.
Can you give me a copy, because they keep you copies.
And then, yeah, James goes.
Judge, are you gonna introduce us or you're gonna let us introduce?
I'll introduce you.
This brass, it's phonetically like a key made of brass,
Brass key. What's her birthday? Her birthday.
Brianne. Just not Brianna.
Okay.
I'm just gonna say. Yeah. Something that the brass. Like the brass. Thank you. No, I appreciate it. I'm still waiting.
Yeah, we need to address one thing real quick.
Okay, well, let me clear it.
Because she has a PowerPoint, but they have some objections to it.
You want to come up here, Joe?
Sure.
Everybody have a good holiday.
Okay, you ready?
I came to this, yeah, without.
So, yeah,
He's supposed to be down here, so.
yeah, but we don't know when. Okay, you ready to go on the record, Ramona?
Yes, sir.
Okay. Let's see, this is Cruz, right? Okay, okay. We are on the record in cause number 256-5785, State of Texas versus Jaime Cruz. Guys, today is July 6th, 2026. It's approximately 10:38 in the morning. Would you guys, with the state going first, please announce yourselves for purposes of the record?
Shantia Shaw, last name is H-A-H for the state.
Okay,
Tyler Flood for Mr. Cruz. I'm ready, and my co-counsel will be Bree Brasky.
you have a couple motions.
I do. First of all, we did file a motion for community supervision, and Mr. Cruz has been sworn to that. He's eligible for probation. We also filed an election for court punishment.
Okay,
And then the state was gracious enough to let me preview their PowerPoint slides. There's 3 issues that I wrote down the number of the slide and the issue. I did talk to the state. So you don't have to agree. You can talk to the judge and whatever, however you will.
okay,
But I'm not using any PowerPoint slides, just so everybody knows. But on PowerPoint slide number 4, the state is kind of, I think it's the beyond a reasonable doubt, and they have different, like, it's not beyond a shadow, things they normally say, but the last one is, it's not 100%. And there's about 3 or 4 other ways they explain it, and then the 100% is the last one. I'm objecting to 100% because it's on the same slide as beyond a reasonable doubt. In order to convict somebody, they have to prove it beyond a reasonable doubt, 100%. That's the standard of proof, not beyond a reasonable doubt, we came close. So I'm just objecting to the 100% as it relates to the verdict.
Judge, 100%, I don't believe it relates to the burden. It's just.
can you show me this slide real quick?
Yes,
Do you
Judge.
mind also? I guess the question is, will jurors, and could they possibly interpret it?
I mean, it might not be that egregious, but I think they do have to get to 100% BRD, or else it should be not guilty.
What do you think?
Usually just when we got office, just basically to demonstrate how, the legislator would not give us an example or a definition of beyond a reasonable doubt.
But I think case has been overturned quite a bit when they try to put percentages on stuff, so.
I'm sorry, you're fading.
Um,
Excuse me, we're on the record.
sorry, Joe. When you put percentages on stuff, if I remember correctly, a case got overturned really recently because someone was using percentages in relation to beyond a reasonable doubt. Can you just take off that one part?
That's
Okay.
not a problem.
All right, what else do you have?
on,
The rest of it's fine.
if you wanna, I don't know if you wanna.
So for purposes of the record, on her beyond a reasonable doubt, the last bullet point had a percentage of 100% with a line slash through it. So we'll take that out, but everything else is fine.
Okay, and good on, I'm objecting to state slide number 6. If you'd like to look at it, it's fine. It's a blank slide, well, white slide, all it says in the middle is, how do you know when a person is, and in red, it says intoxicated. How do you know when a person is intoxicated, question mark? I think that's going to be improper commitment because it's asking the state, the veneer to commit and say facts of, like, if we see this, that's intoxication, not just, so it's not typical, like, have you ever seen an intoxicated person at a party? What made you think they're intoxicated?
Can they not ask that question?
Well, I think it's improper commitment in the way it's asked, because then it's like whatever they say and whatever they think, in my mind, that's committing them to a set of facts that if they see that, that proves intoxication rather than it being based on the evidence and the facts presented.
Sure. Well, let me ask you this.
Sorry.
In voir dire, can someone ask, what factors do you think would lead someone to believe that they're intoxicated?
I feel that would still be improper commitment. However, I've heard them talk about it in other ways that it's still offering signs of what an intoxicated person might look like. But this to me is like getting them to commit to, we're defining what intoxication is.
What do you think, Michelle?
I can rephrase it, Judge, if that's the problem. I can put in it and rephrase it as what signs of intoxication do you know, or but I don't think that it's a commitment.
Say, what's the question again?
What are the signs of intoxication? What signs?
What possible?
You might think somebody's intoxicated.
Well, the question is, how do you know when a person is intoxicated in red? So whatever they say, and if she writes it down or takes those facts down, those jurors in their mind, I feel like that's just committing them to a set of facts that isn't presented by the evidence or the facts at this point.
Well, but they're just trying to.
Just get signs of intoxication and what do they think, but that's why I'm saying I can rephrase it to what do you think are signs of intoxication?
Okay.
What do you?
I think that's fair.
Yeah.
I think that's fair, what she said she's going to rephrase it to.
What do you believe
I feel
are
like,
signs of intoxication?
I think that would be better. It's just
Okay.
kind of ways.
Do that.
on that.
All right, last one.
It's slide number 16. And it's a 2-part. The second part is about punishment. And I talked to the state about how we're going to the court for punishment. And respectfully, I think you were telling me things like, well, they can consider mitigation, they can consider this, they can consider him personally or something like that. I don't think that has any place in what we're doing here, which is guilt innocence for them. They're deciding guilt innocence only. So any discussion about what they can consider for punishment, I don't think.
Yeah, I think he's right. What do you
Yes,
think?
Judge, I wasn't going to talk about what they can consider in punishment. I was just gonna differentiate that, for example, we've had that discussion with jurors before where, oh, but he's so nice, but he has this, a commercial driver's license, it's gonna change his whole life, and it's just things like that. We wanna make sure that that does not affect a decision. Any mitigating factors is not.
Yeah, I don't think, don't get into anything about punishment. really, because they're coming to us for punishment, not to the jury.
Sure,
Yeah.
that's not.
I understand the intent from the state regarding guilt innocence, and I think that's a common request. Don't try to hit on sympathy nerves or I'm not planning on doing that or
Okay.
nothing that's not in evidence.
Could I point out that, part two of the trial is about punishment, which will go to the.
But then you're assuming one thing, right? That's why it's probably not a good idea to, because it could be a very slippery slope.
Yes, sir. Just take that.
I mean, really, you'll have a lot to talk about. Don't worry.
The slide says two-part trial system underlined at the top and then, okay.
Yeah.
Okay. All right. Well, then I'm.
We good?
Yes, sir.
Okay, all right. Let's go.
How long you want to give us, Judge?
20 minutes.
All right, we're adjourned.
Two, three, where's?
One is in the middle. She's in there. You didn't have any what I was going to say. No, okay.
There we go.
Okay.
What do you get, right? For 20. Okay.
All right. All the president accounted for? All right, please be seated. Good morning, ladies and gentlemen. All right. Thank you so much for coming today. My name is David Fleischer. I'm the judge here in Harris County Criminal Court at Law Number 5. This is a criminal court. I don't know how much you guys know. I don't know what kind of life experiences you have. So I'm going to try to start at the beginning so that we get a good understanding of what is what, who is who, what the players are, what the courts are. And I guess if anybody has any questions, we'll go after that. So here in Texas, we have we're talking about criminal. In the criminal realm, we have two types of charges. We have felonies and we have misdemeanors. Does anyone know the difference? Anyone? Anyone? Please. And right when you say something, please raise your juror card so we know who is saying something. You are juror number 20. Okay, ma'am. What's the difference?
If you have a felony, you can vote.
Well, yeah, sure. Yes, there's a lot of consequences. Yes. But the difference between the two is how much time you're facing. Anything a year and below, you're facing a misdemeanor. Anything a year and above, you're facing a felony charge. Now, within those felonies and misdemeanors, there are subclasses because, right, there are different types of charges, there are different types of convictions, there are different types of consequences. For felonies, there are 4 subclasses. I'm not going to get into them now because we are not a felony court. We're a lowly misdemeanor court here. And what we do is we handle misdemeanors that are a year and below. There are 3 types of misdemeanors, A, B, and C. C is the least worst of all the misdemeanors. That's punishable by up to a $500 fine. So let's say juror number 20 gets pulled over for speeding, or juror number 2 or number 3 get pulled over because they don't have registration, and then they get a ticket because they don't have insurance. Harris County is so big that we can't have just a municipal court. I mean, really, from Webster to Katy, from one side to the other, it's 2 to 3 hours. And then in traffic, oh my God, it's even more. So because of that, we have justices of the pieces that are hanging around all over the types of cities. So if you get a Class C ticket, you may go to the municipal court that a lot of people know down here in Lubbock, or you may hit one of the justices of the pieces. Now, let's say something more serious happens. You pick up a criminal trespass, or you pick up a DWI or an assault. Now, these types of charges will land you here in the county court system. This here, we only handle Class B and Class A misdemeanors. Class B are anything punishable by up to 6 months in jail and or a $2,000 fine, technically 180 days in jail and or a $2,000 fine. And a Class A is up to 365 days in jail and or a $4,000 fine. So there is only one county court system here as far as criminal in Harris County. So you pick up a DWI in, Webster or somewhere in that neighborhood, that you might come, I don't even know if Webster's still in Harris County or not, but let's say in Katy, you might come down here all the way from Katy. You have to come all the way to downtown to deal with it down here. So in Harris County, there are 16 county criminal courts at law. Here, we are one of the 16. We handle all those types of cases. As you can pretty well assume, this is a criminal trial today. We will be trying a DWI. I know that everybody has different illusions, different opinions about officers, about the law, about drinking, about this and about that. You know, at the end of the day, all we are asking you to do is one thing. Use your common sense and just make a judgment call. At the end of the day, you guys are and will judge the believability of the witnesses and the evidence. And all we're asking you to do is make a call on what you think, what you believe, hear from what you hear and what you see. It's not rocket science. We're not asking anyone to do Pythagoras theorem, any math, no, just listen, use your common sense, because your gut will tell you if someone is in left field, has no clue what they're talking about, or really understands, knows, and is making sense in what they're saying. I expect this trial to last 2 days, today and tomorrow. Is there any reason anyone cannot be here tomorrow? Not just because you don't want to be here, because I mean, I don't even want to be here, but yeah, I'm just a joke. I do want to be here. But is there anyone that has plane tickets, an unavoidable doctor's appointment that they cannot be here for any reason tomorrow? Anyone? And it's absolutely critical.
No, if I reschedule it, they won't see me until past my case.
Okay, and you were juror number 4. Okay. Anyone else? Anyone else?
I have 2 doctor's appointments tomorrow,
And
a doctor and a dentist,
you are
34.
34. Okay. Is there anyone here that does not understand English or does not speak it very well, understand it very well? Anyone? Okay. So I'm going to now introduce the players that we have here. State, would you please stand up and introduce yourselves to the jury?
Hey everyone, my name is Shantya Shah. I'll be representing the state.
Okay, please.
My name is Jim, husband, I'll be managing the state.
Okay. Defense?
Thank you. This is Mr. Jaime Cruz. Good morning, everybody. My name is Tyler Flood, and this is my co-counsel, Bree Brasky.
Okay. Does anybody recognize any of the players in the game? Anyone? Okay. So essentially what's going to happen now is we're going to give each side time to ask you questions. Now, I know that all of you have life experiences, and essentially what we want to do is ensure that a fair trial is had here. That's the ultimate, what we want. And I got to say, before I forget, I really commend you guys for going. I know that you all have better things to do. I know that you have work. I know that you have whatever it may be in life that's dragging you away and bringing you here. And quite frankly, it's an abysmal showing of the people who actually come for jury service. Probably 5 to 10% of the people who are called for jury service actually make it. It's really such a drag that, so I really commend you and pat yourselves on the back for coming here. It really is something, because we just don't get enough people that really take the time, and it's a civic duty. We take it seriously. And without you, it would be complete chaos. I mean, what would the criminal justice system do without you? So thank you so much for coming. We really appreciate your time, and we will try to be as efficient as possible. Okay, that said.
With the approach, I can't hear you. I'm not going to put approach your point.
Okay.
Do you want it somewhere?
Yeah, just. Let me see, just give me a second, let me see. Gotcha.
They're just starting, we're down here.
The jail's question.
We able to drink water for you?
Uh,
Some, I just didn't know.
yes, help yourself. Hey, I need your help. We're trying to get the PowerPoint presentation working and everything figured out. You need to come down, if not like, we've had a panel sitting. But I don't, that's okay. Anyway, I'm gonna go to the panel right here. Wait. Thanks. I have IT coming, but I don't know if you guys can try to figure it out. Here's a cord that plugs in. You see the cord?
We found Jeff.
Okay. There we go. You might want to turn that one as well and see if there's an on.
Well, thank you.
Is it on?
Do y'all know what input?
Yeah.
You will see that too, yes, maybe. Is there anyone that can't see it?
Not the small writing.
We have someone from IT coming. I just don't know when they're coming here. I mean, we're working for the county. You're lucky to have seats. Really.
Judge, you're messing up your.
I know. We don't just wait. They're
Check with the input is on that.
come up and help us out. Thanks. Is it working?
It's not working, Your Honor. It's on input 3 like this TV is, but I'm not sure why this one's not this.
I have someone coming up now. They should be here any minute to see what's going on. I know that you guys can't see. It's just gonna make it more difficult and you're not gonna be able to.
It's the bottom line and. Yes.
That TV, over there, we can't get it to hub.
Stop.
Yeah.
That is on the same input as that TV, but it's not. Yeah.
Thank you.
You're a rock star.
Can I go home now?
Okay, are you ready, Ms. Shaw? You may proceed.
Good afternoon, everybody. Sorry about all the confusion and all the difference. It is,
One
this
button.
technology, but thank you for being here. My name is Shantya Shaw. I'm the attorney for the state, prosecutor case. As you can see, it's a case of driving while intoxicated or running for short DWI. One request that I have of all of you is that please don't be shy, speak up, don't leave me hanging here. I really need your participation. And it's really important that you participate because we gotta hear from you to know if you're the right person for this jury or, if you have any strong feelings or not about it. So, that's all I would ask you, don't worry. And I don't like you standing here by the whole time, so thank you so much. Number one thing, driving while intoxicated, we have elements that we have to prove. And the burden of proof is always on the state. We have to prove to you on this particular case that on or about May 24, 2025, in Harris County, Texas, Jaime Cruz Jr. operated a motor vehicle in a public place while intoxicated. We have to prove to you every single one of those elements beyond a reasonable doubt. The one that's usually, the reason that I, underlined intoxicated, do you all know, or does somebody want to take a guess why did I underline that?
So,
Juror number 12. Sorry, I couldn't hear you.
it's the level of, alcohol in a certain number in the blood.
That's a good point. Number, you're not repeating.
It's the highest one to prove.
Correct. So that's exactly the point. It's the one thing that is going to be in dispute the most, in most DWI cases. And we have to prove to you beyond a reasonable doubt, every single one of the evidence. Now, what is beyond a reasonable doubt? I'm sure everybody's heard it over and over in every TV series. Does anybody want to venture a guess? I'm sure all of you guys know what it is. You've heard it before. Who's brave? Who's gonna say it?
Can't argue against it. It's obvious.
You're number one. Can't argue against it. It needs to be pretty sure. Correct? Anybody else? Wanna decide on it? So it's a hard one to describe. And let me tell you, it's so hard to describe that legislator didn't even describe it. They didn't give us a definition. They just said, you gotta prove it beyond a reasonable doubt. The way I look at it, or the way most of us look at it, is that we have to prove elements to you in a way where there is no doubt left that you would think is reasonable. I mean, it's just straightforward, maybe that's why, but what we can say that it's not beyond all doubt, right? You can have some doubt about some things, and I will give you all an example soon to make it make sense, but it's not beyond all doubt. Right? Or it's not beyond a shadow of a doubt, same thing, or not beyond a certain percentage. So the cookie jar example. Anybody have kids, little kids? Right? How old are your kids?
3 and 1.
3 and 1, that's a good age. That's the example. How old are your?
10, 42.
Okay, therefore, so, you know how kids are, you tell them not to do something and that's exactly what they want. Now imagine if you have a cookie jar full of cookies, you have it on the counter, chocolate chip, beautiful, smells great, you just make them fresh. You tell them, don't touch that, it's for after dinner. And, or after lunch. You leave the room, you come back, you see the little one, chocolate all over their face, half the cookie jar is empty. And you say, what happened to the chocolate? What happened to the cookie? I didn't do it, I don't know, maybe the dog ate it. I think it's the neighbor's kid that climbed through the window, came and ate it and went, but it wasn't me. Could that happen? Is it possible? It's possible. I mean, argue that, is it reasonable? Once you see that scenario. So that's what we're talking about. Is it reasonable? So talking about intoxicated, which is the most important. What would you guys say are signs of intoxication? If you saw this, number 30. Slurred speech. Slurred speech, wonderful. Journal number 15. When they're not able to walk steady, right? Number 24.
Slow reactions.
Slow reaction, wonderful. Everybody else? Journal number 15. How they respond to people. How they respond to people, right, especially doctors. Number 12. Swerving. Swerving on if they're driving and swerving, number 23. Changing behaviors, right, if you know someone and you're how they behave and it changes, correct. So it's all the above, everything that you guys said. Those are all signs of intoxication, you know, you see, again, you have a 15-year-old comes home, watery eyes, slurring, trying to hide it, I didn't do anything. I mean, you don't really have to give them a test to kind of, this is a mom test. I know you've been drinking, I can tell from your eyes, right? Now, in a DWI case, what we need to do is to prove to you beyond a reasonable doubt, either the person who was driving lost their normal use of mental faculties due to either any drugs or alcohol that was introduced to the system, or lost their normal use of physical faculties. Or they had a blood alcohol concentration of 0.08 or above. We don't have to prove every single one, right? So as long as we prove in some cases, it could be that we only have the loss of normal mental faculty. In other cases, it could just be that a prosecutor proved to you a reasonable doubt loss of physical faculty. And in other cases, you could have 2, you could have 3, but our burden is only to show it to you or to prove it to you under one of those things. Does that make sense? Anybody have a question?
Excuse me. When we speak of DWI, are we only speaking of alcohol? And are drugs labeled under something like DUI or?
No, drugs in Texas, drugs also are included under DWI. So if you are impaired in any way, whether it be alcohol or drugs, is still a DWI.
Okay, thank you.
Yes, sure. So let's talk about loss of normal mental faculties. When you hear that, what do you think that means? Impaired judgment, number 26. Anybody else? Anything else?
Someone being aggressive, violent, so maybe not in their personality when they're sober, but when they're intoxicated via alcohol, via drugs, it can change their whole demeanor, their personality. They can turn with violent tendencies, whether it's to an officer or to anyone else.
That's correct. Juror number 7. That's change of behavior, basically, correct? Oh, jump number 10, sorry. And juror number 30.
Sometimes, you are so accustomed to pulling out your debit card more than anything else. Can I have your ID? My credit card.
Exactly, so it's just you're not operating as your own self, the way you are usually normally. Every day, you're not behaving the same way, you're not acting the same, you're not thinking the same way. It could also be slower, so loss of physical activity. Okay. What do you think of when we think of loss of physical?
And walk.
And walk, exactly, juror number 27, thank you.
Losing coordination.
Losing coordination, you may be able to walk, but you are not coordinating. Juror number 23.
Slower reflexes.
Beautiful, slower reflexes, why do we need our physical faculties, our reflexes to be all in touch? I mean, you all know, there's just so much to pay attention to when you're driving, it's not just one thing, there's pedestrians, there's lights, there's, you know, give me examples.
Pedestrian.
Exactly.
Cars.
Cars.
They lose also their depth of perception.
Yeah.
Of how far an object may be, because they're drunk or high, they don't know.
Exactly.
You could be right there, and you could look like you're standing over by the judge. You don't know, I could be hallucinating
Exactly.
and
So
not
that-
driving.
Yes, that's a good point. So sometimes it could be that you may seem completely normal, but due to the alcohol that was introduced, you're still not operating as your usual normal self, physically. And you're not able to pay attention to 5 things at the same time, or 6 things at the same time, which is needed for driving. And, the last one is straightforward, right? If we show you alcohol concentration of 0.08 or higher, that's what's under the law. Whether we think the person, just looking at them, oh, they don't seem drunk, doesn't matter, right? If it's 0.08 or above, then under the law, you're driving under the heat.
Excuse me, I think one thing we forgot was the double vision factor when they're driving and the car could become a judgment appeal. In fact.
That's a very good point. Well, and that's, juror number 18. And which one would you say will fall on mental or physical capacity? Yes, juror number 20.
If the blood alcohol content is 0.8 or higher, is it done deal?
Yes, so when that
Yeah,
one,
I'm sorry, I don't mean to interrupt, but, since Texas, objecting to that statement. Driving while intoxicated, 0.0 higher must be proved that they were driving with that number, not at any point in time.
Right,
right, so
that's correct.
when you're driving, well, and you have an alcohol concentration of 0.0 and above, then under the law, you are considered to be driving under the influence. That's the law. You still can, because everybody gets to have their day in court, and it is our burden to prove that that was their, alcohol concentration. So, yes, there are a lot of trials where we might have that number, and it is still going to be trial. Yes, number 23.
I have a question. So if the person doesn't have concentration of 0.08 or higher, but has either loss of mental or physical faculties, is that still considered intoxicated?
Yes, so that was what I was trying to say. If we prove it to you through the rest of normal, mental faculty by just the facts of the case, and the evidence, then that's one way that you can find. All right?
Yeah, I just have it
A drug, I don't mean to speak, a drug will not show an alcohol concentration.
Exactly.
Methamphetamine, any drug, Xanax, any drug will not show an alcohol intoxication. Unless the alcohol is mixed with the drug, then they will blow over a 0.08. But if you're impaired by a drug, which you said at the beginning, that drugs also are a factor of the DWI. They will show the mental and the physical, but they will not blow the concentration because it's a drug and not an alcohol.
I could have said it more perfectly. So it could be, that you have lost one of those. So that's why we have to only prove to you one of these. If there's more, cherry on top, but that's our burden. Now, let me ask you, is there anyone here that would say, you know what? I understand that's what the law says, but unless you show me, blood concentration, blood alcohol concentrations, or what we call BAC, of 0.08 and above, I cannot find guilty. Juror number 20, juror number 17, juror number 24. Anybody else that would raise the verdict? Yes.
Underlining the normal. They pointed out that out of the court before, is that something important for this as well, in terms of proving what he is, where it is almost speculative.
Yes, what is normal? I get that question all the time. So, what I would say to that is, what would you consider for driving purposes as normal? If the person has gotten a driver's license, that means that normally they can operate the car the way they're supposed to, right? And once they are not, for example, there's a traffic violation. Could it possibly be a sign? So it's just that you look for the signs, and we will point them out also. We will have, we'll have evidence to help you decide, well, if it was normal, or if it was outside the norm. Does that make sense? Or does that answer your question?
Yeah, that, I guess
Get your voice up, please.
my experience is the normal shit pretty drastically throughout the day, especially depending on my medical conditions. So
Yeah.
I don't know how.
But what I mean is just absent medical condition, because that's what we also ask, but if absent any medical condition, just by introduction of either alcohol or drugs. So anybody else that would pretty much, that would be raise our burden and would want us to show all three, or two at least.
I have a question, I may be jumping the gun a little, but was there a witness available? Is the arresting officer available to give testimony and show us the results of whatever tests, roadside
So
tests?
I'm not able to really talk about the facts of the case, but hypothetically, that's evidence, right? We have to show you evidence. We can't just expect you to believe what we're saying, right? So that could be an evidence, part of the evidence,
Okay.
witness testimony, right?
2 minutes, Michelle.
Okay, I'll have to move on to this. Covers this, sorry, it just covered this. So as far as, is there anybody here that would think, I'm not the right person to sit in a jury for a DWI? Juror number 20, juror number 33, juror number 8, 16, 34, 24. May I ask why?
I don't trust cops.
I don't think so, I don't know what.
So isn't this your opportunity to make sure that things are done the right way? You know,
I don't believe in the system.
this is your ability and time to shine, to ensure that the process has gone through correctly. I mean, imagine if everybody has, would we have a criminal justice system, right? We depend on jurors here who, that's why we pick 35 just a completely random people who don't know Adam from whoever, so that you all can take a look. Just, you get a set of facts, take a look at it and make a decision. Just use common sense. It's not,
I also don't believe it's my place to decide someone's fate.
Sure, okay.
So, everybody has their own personal beliefs, right? It's completely fine. That's fine if you believe that. It's okay. We just need to know is there anyone else that feels like juror number 20? And it's completely okay if you do. We just need to know about it.
And time.
Well, thank you so much for listening to me. Thank you for entertaining me. And sorry again about the technology issues.
May I?
Please.
Good morning still. Good morning. Got great news for you. I only get to talk to you for 20 minutes, so this won't take that long. When I first started trying jury trials, I kind of thought nobody really wanted to be here. And I said, kind of as an icebreaker, raise your hand if you don't want to be here. And a few people raised their hands. And then I saw people looking at me, but then they were looking around behind me, and I turned around and the judge's hand was way up in the air. I know Judge Fleischer made a joke about that, but, and I specifically raised this hand. Are there anybody DIYers out there, people who like to do home projects? So, right, me as well. However, probably less now after this, but I'm 55 now. We're not as bulletproof as when we were like 19 or 20. But I had drilled, and the drill slipped off and went through my hand and got a very serious advertising fasciitis and had to have emergency surgery. So I'm still healing from that. You see that? That's what this is. But that's not what we're here to talk about. And I'll try to,
But thank God you still have your hands.
exactly.
Are you looking for sympathy?
I just wanted you to know why I've got your That's up to you, but we're not supposed to do any of that. You're not supposed to judge this case based on just the facts and the evidence that the government can show you, right? I appreciate the joke, but no, real quick, the doctor said if I hadn't come in that night and they perform surgery, I would have a hand or arm.
That's right. Absolutely.
I've never had an infection like that. I don't know if anybody else has. It's like
Bad juju.
right, so I'm being much more careful now. Okay, first of all, you know that we're here on a DWI case. You will become, or 6 of you will become the judges of the facts. And what that means is you'll be sworn in as a juror. You'll say, okay, you charge somebody with something, and all of your focus and attention and scrutiny is directed over here at the government, at the state. You're not judging Mr. Cruz personally. As a matter of fact, we don't have to prove anything. He doesn't even have to talk or take the stand. You're going to be looking over here saying, okay, show me what you got. And I might hear some evidence, but it might stop somewhere, and it might not go all the way up, kind of like a mountain, not all the way to that summit, to the peak, and they might not have enough convincing, credible, strong evidence that it reaches beyond a reasonable doubt. And anybody, so if they don't prove their case, if you see everything that they can show you, and you're like, okay, I still have reasonable doubt, or it wasn't really enough. What is your verdict? What is not guilty? You have two choices, guilty or not guilty. There's no innocent on the verdict form, so what is not guilty essentially mean? I wish I could offer you a water, or you.
I have it all, I'm sorry, yeah.
No, it's just. Not guilty means not proved. Okay, everybody with me on that, juror number 3? Is anybody, I mean, that's essentially you're saying, okay, I heard some stuff, but if it's not proved, then that's when you say not guilty. Okay, that's what that means. We're not here in defiance of DWI laws. You know, I'm a native Houstonian. I grew up in Spring, went to Klein High School. I've got 2 boys who are 21 and 18. And these are the same streets that I drive on. We've probably passed each other before. We want the streets to be safe. We know that DWI can be a real problem. We are here in trial today because we need you to look at what they got to see if it's enough, you know, to saddle a person with a criminal conviction for the rest of their life. We're obviously here today because we believe that Mr. Cruz is not guilty of DWI. It's no secret. But we're not here saying that they're bad laws. Everybody should be able to drink to the point where they're intoxicated and then go drive. That's not what we're here saying. It's, you put some words on a piece of paper, you gotta prove it beyond a reasonable doubt. So is there anybody here that, you know, there's 35 of you, the judge described or explained how we just need 6. So we understand this might not be the perfect case or the right case for everybody. Like my car's been broken into 2 times. When I've been in trial, after trial was over, and they stole all my computers and my trial stuff. So if this was a burglary of a motor vehicle case, I would raise my hand and say, not the right case for me. I mean, I think I'm a fair, law-abiding citizen. I think all of y'all are fair, nice people, but that doesn't mean that this has to be the right case for you. We're not trying to make it the right case. We have enough of you that we understand everybody's got different life experiences. That being said, I'd like to ask you about that. Some people have lost loved ones or been hit by a drunk driver, or I've had some jurors that have grown up in you know, an alcoholic household. And I had one juror, a young guy, I thought he was going to be a great juror for us. He didn't really say anything until the end. And then he said, Mr. Flood, your client's already guilty. Right now, you haven't heard any evidence, right? And we've all heard of the phrase presumption of innocence. And that's something we all enjoy. Right now, Mr. Cruz is absolutely presumed innocent. So if you had to vote right now, the law would require you to say not guilty. But I can explain what the law is, but that doesn't mean you have to agree with it. The only thing you've promised to do right now is just tell us the truth about how you feel, and there's no wrong answers at all, okay? So one of these jurors at the end, he said, Mr. Flood, I think your client is already guilty right now. You're wasting our time, and this is during this process. And he had grown up where his father would drive he and his brother around drunk all the time. It made such an impact on him. Where's your number 11? It's not picking on you, but he had a very strong opinion, and there was nothing wrong with having that opinion, but it's good for you to tell us this stuff. That's the other thing too. If you, some of you have been on juries before, right? If you, and you've probably learned this, but for those of you that think if I just sit here and don't say anything, I won't get picked, it's the opposite of that. So if you really want to be on this jury, don't say anything. And the reason is simple, because they're listening to what you're saying. We're taking notes. And if you tell us how you feel or about anything that, you know, could potentially affect you, if you were a juror on this case, we need to know about it. And that might be a reason that we would excuse you or let you go home. If you don't tell us anything, we assume that there are no issues, you're gonna be perfectly fair, neutral, unbiased, and you're gonna be on our jury list. Okay, so that's a little fun fact to know and tell you can pass on to your friends and family. But what's important, kind of going to the next step is raise your card if, so I'll give you a second to think about it, but have you dealt with anything related to DWI? Experienced any emotional or traumatic experiences in your life, whatever that may be, that we need to know about. And you might say, that's impacted me so deeply, I'm probably not the right juror for this case, or I can't promise you that I can be fair, whatever the reason is. And I'll start with the first row, if that's okay. Raise your card on the first row if you've had any experiences with something like this, or it hits close to home. Juror number 5.
Yes.
No, I'm sorry, let me go, juror number 4. Okay, it's kind of like an auction, if touch your ear or nose, if you want to call on you, I think you have something to say, but yes, juror number 4, what's on your mind?
I almost
Would you mind speaking up just a little bit louder?
I almost lost my aunt to
Okay. She was in a crash? Okay, I'm sorry to hear about that. Has that made a big impact on you? And if I was to ask you, so we need 6 jurors that can set aside any of that outside the door and just judge this case based on the facts and evidence that they would present. Some people say I can't put that outside, and that's affected me that I'm already, we use the B word, bias. It's a strong word, but, if you, like one of the people in the field department seems better than the other, that's a bias towards them. So we need to know, can you look me in the eyes and say, despite that you can be completely fair to Mr. Cruz? Or another way to look at it, there's the presumption which Mr. Cruz enjoys right now, but maybe you're not all the way at presumption of innocence. I mean, you're not saying he's guilty right now, but maybe you're saying I'm not presuming him completely innocent right now, or I'm already biased even a little bit in favor of the state right now without doing it yet. Tell me how you feel. Can you give me a guarantee that that won't affect your decision making in this case? Can you say that a little bit louder? Okay, so you're saying, I guess, the flip side is that experience could affect your decision making in this case? Yes, okay, thank you. And juror number 5.
Yeah, my uncle has had an intellectual.
Okay.
And I grew up with like a lot of men in my family drinking. So.
Okay. So kind of same question. Is there anything about that you think, this might not be the perfect case for me? Or all the questions I asked juror number 4, do you think that you would have an issue saying, I can set that aside completely, and I promise you I can be completely fair to Mr. Cruz in this? Or would that cause you to maybe already be starting to stay off ahead, or you'd be thinking about that in your decision? Could it affect your decision making in this case?
I think so, yes. I think it could affect it. No, I don't know for sure.
Okay, can you give me 100% guarantee that it would not affect your decision making in this case?
I can't give you 100% guarantee that I won't affect my decision making.
Okay, thank you. And who else in the front row? Number 7.
My mother-in-law was a drunk. Was arrested for driving on sidewalks.
Okay.
And my daughter-in-law's brother was hit by a drunk driver. If you know what the work. Lost his career.
Okay, those are pretty big. Same kind of question. Do you think that those incidents could potentially, or they would affect your decision making if you were a juror on this case?
Yes.
Yes, okay, thank you. Juror number 8. Oh, my dad's had multiple legal guys. What was that first part? My dad's had multiple legal guys. Okay. It would definitely affect me. It would definitely affect my. Judgment. Okay, so we haven't heard any evidence right now, but just that experience alone, you think that would. You said it would definitely affect your judgment in this case? Okay, thank you. Anybody else on the first row? Second row? Number 14?
My son, when he was in high school, he was taking his minor in possession.
Okay.
He went through the field sobriety test, and since they didn't take him, then I was on the pass. There's that, my wife's parents were alcoholic.
Okay.
And many years ago, was involved in drunk driving accident, or drunk driving, actually back into the stop.
So you've had like several different. Okay. How do you feel? Do you think you can set all that out the door and not think about that in judging this case, or could it affect your decision making those incidents? Where you're already kind of leaning.
I think pass, yeah.
Okay, and so when we go up to talk to the judge, as soon as I sit down, if it's, I think, or maybe some of these questions can be challenging, I can only use yeses and nos. Can you give me a guarantee that you can set those aside and you won't think about those, or they won't come into play in your decision making in this case?
Yes.
Yes? Okay.
Ladies and really, we've all had one effect or the other, but really, just common sense. You guys know what's real. You know what's not real. You know when someone is blowing smoke. Just listen, make a judgment call. It's really just not that hard. When you listen to the evidence, you will know in your gut, oh, right, what the hell, what? So really, that's all we're truly asking. Everybody has had, well, not, I shouldn't say everybody, most people have had some kind of experience, whether positive, whether negative, but really, none of that matters. Listen and just make a judgment call.
How am I doing on time, Judge?
Yeah, 8 minutes.
Thank you. Who else on the second row? Number 16?
Well, I just got a silly, but my husband.
I'm sorry, ma'am.
My husband was.
I'll stand over here so, I can hear you better.
Can you start over, please? Okay, my husband, this is gonna sound silly, but my husband is not a heavy drinker and he had one beer and just because he was speeding, he got stopped and the cop told him, well, I'm gonna have to take you in because you smell like alcohol. And that affected our finances and, yeah, our lives. So I don't think I could be the jury in this case.
Thank you. Who else? Juror number 18?
My sister-in-law, 3 weeks after her 20th birthday, was killed by a drunk driver.
Oh, thanks. Sorry.
But I could still listen and be strong.
That's a pretty big event to deal with. But you have no issue saying that I can set that aside and still be completely fair in judging this case?
Yes.
Okay. You're not starting to state out ahead or like even a little bit biased. Okay, great. Thank you for sharing that with me. Who else raised their card? I think 20, you talked a lot, took good notes. I think you're good now. You're not raising your card.
Oh, no, I'm hot, sorry.
Okay. Number 22.
Yeah, I have several, all over a dozen close family members that are former or current alcoholics and have many DWI convictions. My mom, who also got into a drunk driving accident. Not just from it. So
How do you think that would, or do you think that would affect you if you were a juror on this case?
I would imagine you can go fast.
Well, so
complicated.
right now, you haven't heard any evidence. So this is, I know it's hard. It's hard. We're not allowed to talk about the facts or the evidence. We're gonna have to get you to give us a yes or no, pretty much knowing nothing about the case right now. So it's kind of the same questions. Can you give me that guarantee that you can be completely fair in this case and set all of those things aside? Or would they potentially affect your decision-making in this case?
I'm sorry, sir.
No, I don't think it can.
You don't think you could,
100%.
okay, you don't think you could be completely fair if you're not 100% sure? Is that what you said? Okay, thank you. Who else? Is that everybody on second row? What about third row? From 23, yes, ma'am?
Several members, I grew up in, not only a household, but with grandparents and uncles who drank and drove. Never in an accident, but it was always a little tense.
Right.
I think I could, I would like to hear the evidence before.
Yeah, I think everybody's in the same boat. Right. I noticed also, are you and your spouse and you work in corrections? No, who is that? Somebody close to you, number 30, right? Oh. So hang on one second. So it's the same thing, you can promise me that you can put those experiences aside and just judge this case on the facts that they present or don't present?
Yeah, depending on the evidence, yeah.
Okay, great, thank you. Who else on the third row? No, number 24?
I don't think that there's an excuse at all for anybody to buy the wheel. One beer or not.
Right, so any amount of alcohol, you shouldn't drive. Okay, so their burden of proof is, they have to prove a person was driving while intoxicated beyond a reasonable doubt. But you are not unlike many jurors that have come in here and said, I understand what the law is. You can drink out, when I was growing up, you could drink alcohol and drive at the same time, but they changed that law. You can still drink alcohol and then drive your vehicle, as long as you're not intoxicated. That's the law, but it doesn't mean that you have to agree with it. And I call this like zero tolerance. So if their burden is way up here or wherever, you set it beyond a reasonable doubt. We talk about this like lowering their burden. And the way I ask this question sometimes is if you heard evidence that a person consumed any amount of alcohol and then drove, is that enough that you would convict them?
Any.
Any.
Yeah, there's no excuse.
Okay, so any amount of alcohol and driving would be a conviction to you, and you would not make them prove driving while intoxicated beyond a reasonable doubt?
Anyone had any alcohol at
Yeah, 1 minute, Tyler.
And if they drive, that's all? Okay. Is there anybody else what is your number again? 24?
24.
Real quick, is there anybody else that feels that way also? Because I don't have enough time to go through everything I wanted to. Raise your card real quick that you feel that it should be no alcohol and then get behind the wheel, even if you're not intoxicated. I see you're good, number 24. And so, but then my follow-up question is, well, so number 5, number 31, number 32, and number 33. You feel that the person should not be able to drink any alcohol and then drive. So if you heard evidence that a person drank some alcohol and then drove, but they didn't prove an intoxication beyond a reasonable doubt, do you feel the same as juror number 24, that you would find a person guilty just because they drank alcohol and then drove?
Yes.
Number
Yes.
32, yes. Number 31?
I can answer that for sure, because everybody's normal is different.
Okay, and number 33?
I don't even know why law allows certain percentage.
Should
What
you?
was that? So I don't like age bill allow anything, now, why do you allow someone, why do you not allow? Everything is.
I'm sorry.
I can't hear her either.
I don't drink alcohol, so I don't know what effects it has, but I don't like the fact that law allows certain percentage. I don't like anybody drinking, driving either, so it's harmful for not just them, somebody else, then don't.
So I don't have much time. I just need if you don't mind, a yes or no. Do you feel like these other jurors that if you heard evidence that a person drank any alcohol and then drove, you would convict them based on that? Or are you still going to require the state to prove beyond a reasonable doubt they were intoxicated.
That's why at least I don't belong to this case, because I don't like the fact of state, I was anything.
I get that. I'd love to have a long talk with you about this, but I just need like your final answer. Would you, is that evidence alone enough that you would find a person guilty? Because, I mean, you feel strongly about it.
Time after this, Tyler.
And if they drank some alcohol and then drove, is that enough that you would find a person guilty?
Yeah, I don't understand the factor, so there's no yes or no, as a grade, so that's why I don't belong.
You don't belong on the, okay. Is there anybody else? Judge, I know that you told me sit down.
I didn't give them any more. I
DWI
mean,
experiences, I didn't get to finish that. Can I just ask that broad question, please, and then sit down? I didn't get to everybody. Raise your card real fast. If there's anything else you didn't share with us yet, that is an experience in your life related to alcohol or DWI that you think would affect you if you were a juror on this case, or that would cause you to not be a good juror, the right juror for this case? Nobody else? Okay, well, I really appreciate your time and your answers. Thank you very much. Thank you, Judge.
okay. All right. Lori, if you want to come up. Tell me when you're ready, Ramona.
Okay, Judge.
Are you ready?
I'm sorry, Judge, I hear like what's on the Zoom. Okay, go ahead.
All right, we good now?
Mhm, go ahead.
Okay, so are you, okay, so far, guys, I have for cars, I have 4. 16, 22, 24, and 32, and 34. Yeah. So far, I said there's 1, 2, 3, 4, 5, 6.
I have those two, Your Honor. I have
Okay.
additional ones.
Okay, who do you have? So, hey, I'm gonna first ask them if they have any cross challenges, and then I'll go to you.
Okay.
Okay.
Number 5, his last answer was he couldn't guarantee that his past experiences won't affect him.
What do you think, Tom? Yeah, okay. 5 this one.
Number 8, I have that he said his dad's DWIs would affect his judgment.
Okay, 8.
14 said they were gonna be okay. 16 we agreed on. I have for number 17 that he needed a number or he would not be able to.
You're number 17. Could you please come up? Come on up. Thank you so much for coming. Thank you for coming. So understand that with the passage of time, right? Technology gets greater, gets grandiose, you know, back 30 years ago. Shh.
Back 30 years ago, we didn't have blood test. We didn't have breath test. We may not even have videos, but you still have DWIs. With the advent, you start slowly getting more things to help aid either the state or the defense. So one of the questions that's asked to you, with that in mind, one of the questions that's asked for you, a number. Do you have to have a number? No one is required to produce a number this, number that. Yes, they may have one, but they may not have one. If they don't have one and they produce evidence, would you still be able to find someone guilty?
I mean, it's kind of hard for me to figure out really the facts.
That's the point.
It's
That's
so
the point.
subjective.
I know,
I can't even.
but imagine this.
One at a time.
Imagine this. You have a video. You see somebody coming out. They're talking completely incoherent. There's urination. There's vomit. You know, but there's no number.
Kind of subjective. Don't know if I'm so if you're asking me that.
Sure. And then again, who knows what number might be right or wrong anyways, right? So that's why we don't know what evidence is out there now. All we ask is that you listen and make a judgment call. There may be a number, there may be, I have no idea. I truly, I don't know. What do you think?
It's difficult for me, just based on what we're discussing here. Yes, if it's extreme one direction, obviously common sense, but if it's somewhere in the middle, no. Because even like the sobriety test walking the straight line, if somebody's nervous.
Sure, absolutely. But then that's why we need you to take a look at the evidence and make a judgment call to see. You will be provided with certain things. I don't know yet, but certainly one of those is the law, and you'll be able to look at what happened, look at the law, and then make a judgment call.
It's hard for me to see.
Can I ask the question? So if we went through trial and after trial, you believe that I proved every single element to you beyond a reasonable doubt. So you've heard everything, we're done, but you believe I proved everything beyond a reasonable doubt, except I didn't give you a number. Even though you believe I proved everything beyond a reasonable doubt, if you didn't have a number, you should be able to find this defendant guilty. I need you to give me a yes or no on that.
Yes, without a reason.
Okay, so if you believe that I did prove every element beyond a reasonable doubt, but you didn't get a number, you would still be able to find the defendant guilty.
But that would be, it would be even an extra burden to include those two.
So you would raise my burden?
Yes, because they don't have that, so now I have to.
Okay. I'm good with the question.
He lost his mental peace.
Yes, it had to be beyond that, we just express. Probably would be extra.
And so this is based just on reference that we need to put in here, be able to make some of that. That would have been basis very good properties. Physical properties. At that point, you're saying that you would agree to bring
Correct.
Just so you know, it's totally cool if you need a number. Like if to you need a number, that's perfectly fine. Like no one's gonna get mad. We just want you to be honest. I don't want you to feel pressured into saying that you could be.
Pretty honest when I tell you that it's a high bar for you to convince somebody based on subjective evidence. No, that's what I'm trying to say.
Do you think that mental or physical is too subjective?
Okay.
There are obvious when there's. I don't know this person, I don't know his day-to-day interactions.
Yes.
Okay. Thank you.
I'd like to try to be up.
Yeah.
Yes, what number was he?
Number 17.
17, okay. So 17. Okay. Yeah, we kept going back to the.
He kept saying the other thing. If he wouldn't have added the, would it be high for me, then I would have been fine.
Literally kept going back to stuff. Okay.
17.
Anyone else?
Oh, before we get to those, I still have some time to discuss. So after 17, I had number 20, stay at the day of trust cops.
Yeah. Oh, no, that's, which one? That was 20.
Yes, for number 20, I had that they need
Yeah,
a number
20.
and that they don't.
Yes.
Okay.
Yeah, there was, yeah. You know, 20. Yeah, I totally forgot about that one. Yeah.
24, we agreed on. 32. 33.
I didn't do that one.
33, I believe, agreed with the any amount of help. It was those last three people that you questioned.
Oh, yeah, okay. Hey, there's, yeah. Yeah. All right, anyone else think? So 17, 20, and then 33. I'll put it in order here soon. Yeah, 17, 20, and 33. Yeah, anyone else?
No.
Okay, sweet.
Judge, can we go over?
Can we repeat all of them?
So far I've got 4, 5, 8, 16, 17, 20, 22, 21, 32, 33, and 34.
The only one that we're missing is 31.
Was 31, 32, 33.
I didn't put them in. Did we talk about 31? For cause? Okay, 31. Okay. Defense? Okay. Aside from all those, yeah, I think 7. I'm with you on 7. No, I'm with you. Is that it?
Yes.
Yeah. I mean, do you have anyone else besides 7? I mean, I took most of the ones that you had already. That's it, right? Yeah, we're good? Okay, thanks. All right, so guys, let me see, we have a total of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Oh, we're good. Okay, I'm gonna put one alternate just in case. So we're gonna call 7. So that should give you an extra alternate directory if you need it. So it should be enough. All right, 5 minutes, because it's. We'll start this Monday. Okay.
So I think are we up to 10, 9 from the? Yeah.
So. I think so.
Okay.
All right, are you ready? Hey, 5 minutes. Go. All right, so what's happening now, ladies and gentlemen of the jury? We are whittling out people who initially we think shouldn't be part of it at this point. The next thing is the lawyers get what's called peremptory challenges. Those are challenges that they get to make for people who they don't think they should be on the jury. And they can make any strike, virtually any strike. There are a certain few reasons that they can't make a strike, but once they've done their strikes, we will get their list. We reconcile the strikes with the list, and at that point, we will call a jury to come up here. I'm giving them only 5 minutes so we can try to get you out of here quick, okay? So just bear with us, give us about 5, and then we'll be with you.
Yeah. Okay, so at the 4, 5, 7, 8. I'd be home, I'd be at home. I'm recalling things. And then I'm watching the work, so I look here and I do all now, do all good stuff. He's been carrying it under the watch. I'm sure I see my phone.
That boy is 27 years old.
Yeah. I was trying to do the cutoff in my head, but I can't really. But yeah, you used to do the direction using it as well.
You'll swear or you want to swear? No, no, you got it. You got it. You're big time. So. No, we're waiting on two jurors. They're back? Okay, yeah, let's go. All right, ladies and jurors, ladies and gentlemen, we're going to call your name. When you hear your name, please stand up. And if you would make it on down to the jury box.
All righty.
Guys, if you want to kind of maybe.
Juror number 2, Kayla McCall. Juror number 3, Steve Van Armstead. Juror number 6, Yvette Election. Juror number 12, Cynthia Brogan. Juror number 13, Omar Guzman. Juror number 15, Cheryl Ivory. And juror number 19, Julie Cray.
All right, so everybody can be here tomorrow, right? Bright and early? Okay. Any objection from the state? Sure. Did someone incorrectly get called? I don't have 15. We had 16. We never had 15.
She couldn't get in partial because her husband, that's everything. For delivery.
I don't have it. I don't know.
Can we ask if she talked about her husband being there?
No, that's the one that's.
Mhm. 16.
Yeah, I have those.
16.
Okay, we're good.
Okay, so no objection from the defense, state? Any objections? All right, so state and defense have no objection to the panel. Guys, would you please rise and raise your right hand?
Do each of you solemnly swear that in the case of the state of Texas against the defendant, you will a true verdict render according to the law and the evidence, so help you God?
All right, you may be seated. Ladies and gentlemen, you are done with your jury service for today.
Thank you so much for coming. I hope that it hasn't soured your experience too much and that you will, if you get called, that you will continue to come. We need you. Your excuse. Yeah, we've got all kinds of passes, and if you want to speak to the bailiffs, they can give you anything that you may need, a work excuse or a bus pass or. Hey, do you have a copy of the information? Let's arraign, and then we'll cut loose. Hey, guys, do you mind just taking a seat back? Mr. Flood, you will arraign and then we break. All right, guys, if you just keep it down, we're still on the record now. We're going to arraign, and then at that point, we'll cut loose. State, are you ready? Okay.
In the name and by authority of the state of Texas, comes now undersigned Assistant District Attorney of Harris County, Texas, on behalf of the state of Texas and presents in and to the Harris County Criminal Court at Law Number 5 of Harris County, Texas, that in Harris County, Texas, Jaime Cruz Jr., hereinafter styled as a defendant, here to on or about May 24, 2025, did then and there unlawfully operate a motor vehicle in a public place while intoxicated against the peace and dignity of the state, signed Assistant District Attorney.
To which the defendant pleads.
Not guilty.
Okay, we are done. You may be seated. Ladies and gentlemen, that concludes your service for today. I will ask you please to get here promptly at around 9 in the morning. Once all of you are here, we will begin. I will try to be as efficient as possible. I know that your time is valuable and we will try to be really as fast as possible for you. While you're out, please, please, please do not do any independent research. Do not talk to anyone else about this case. Do not talk to each other about the case, about anything, until you guys are all together here. Don't just talk about anything. Once we get you back here tomorrow morning. Shit. Sorry. We'll begin tomorrow. Anyways, your point of contact will be the deputy here. If you need anything, just let them know and then they'll be able to take care of you. And again, we'll see you tomorrow morning. All right. Thank you so much for coming and being of help. Boy, that was a party foul. Are you ready? Joe, I just need a deputy to bring them out. I don't know where that you're going. Is that you going back there? Okay.
Mr. Cruz,
Yeah, you guys are good until tomorrow. Yeah, sorry, Tyler. Oh, off the record.
Sorry.
Mr. Frank. Talk to me, bud.
Back again on, lady, Davis,
where, you're requesting the person to take another drug test. She had taken the drug test. But she only been out of jail for 20 days. So she did have some marijuana in her system. And then you order her to take another test within a matter of a few weeks. At this point, you would have just compared the test results. So we'll hear back.
What's the last name?
Davis.
And say they just filed another bond violation, no?
Yes, we, as of this morning, did not go through the test results been sent before, for court appearance. And so the.
I didn't revoke her bond.
No, sir. And the results are in. I do have the results. That was my mistake. She gave me the results maybe a few days ago.
But you keep saying that there's a mistake, and yet, you know, you're trying to take the fall for her. That's what's going on.
She gave me the results a few days ago, but I was going to bring the results in today. And so I saw the bond violation report. I immediately just sent them in what she sent me already. So she did take the test.
When?
Well, that was the second issue, so the test was done on 6/26, but he wanted her to test between 6/29 and 75 in order to get that full to go past. So we rejected that.
And I have to explain that to you, Judge. She got a notification.
Where is she?
She lives in Ohio.
Okay, I'm ordering her appearance. I just can't get anything straight. I don't know what's going on. So I'm setting the case off for a week. She's got to be here. Enough's enough. Really, I'm giving her another week now. I hope she tests negative, but really, I can't get anything straight. I don't know what the hell's going on.
So she does have the results, Judge. And I'm trying to know, she did test negative for everything, including alcohol.
Did you see it? Does it look legitimate?
It looks like it was cleared. There was some cutoff on the bottom, so like.
No. I want a legitimate lab test from a Quest diagnostic, not some thing on a burner phone that, like, you know, what it looks like there. Does it say anything about?
Now, she did get tested for Quest diagnostics.
The screenshot here says alcohol metabolites negative, amphetamines negative. It doesn't give me where it was done, where it was. It's a screenshot from a cell phone.
Right. If you look at the top, the very top, you'll be able to see the Quest.
I don't see it.
Experience.questdiagnostics.com.
I don't know where you're looking at. I don't.
Hold up, so this is when it was sent to us, but bottom is cutting off the results, so we can't see anything to do.
It's unacceptable, man. No, I mean, not really. Enough. I'm sorry. Enough's enough. I'm putting her on for Monday's docket. She's got to be here. I'm giving her a week, but enough's enough, man. We've played this game too much. All right. So just let her know she's got to be here. If she fails to come. Thanks, Mr.
Thank you very much.
All right, man. Hey, are you ready?
Yes, sir.
Thanks for being patient.
No.
What's up?
I have Ms. Vasquez. I was appointed to, I believe this is the case where she had a criminal mischief and they picked up a PTO and was taken.
Correct. Yeah.
That's all I know about it. I was just appointed. So I guess I just want to make sure my understanding is correct.
So certain conditions, she now picked up a VPO.
Right.
I'll leave the original bond. I'm revoking the mischief, but I'll leave the other one as is.
Okay. You sure you're gonna set a new bond?
5,001.
Okay, that's what I was worried about. All right, so we're good there.
Just, she needs to be admonished about, and I'll let you do it just because we're that, enough's enough. She picks up another one, I'm gonna go.
I told her that.
I trust you.
I'll reemphasize that to her.
Yeah, I trust you, man.
Okay.
You got it.
The other person I have, I think she's already had bond conditions, is Ms. Ramos, who had a DWI and FSGI.
Yeah, you're good to go on that.
Already. Okay.
Yeah.
All right, we're
Yeah,
good to go.
okay.
Thank you. Thanks.
Hey, is Etcha going to bring in, okay. Yeah, he's been waiting forever. Please. Joe, Okay, come on.
Good morning, Judge.
Hey.
I have Nichols set for trial tomorrow. I wanted to see if you would like us to still approach tomorrow or if you are okay with this resetting.
Yeah, go ahead, reset it, but don't do a long one. I mean, do 30 days.
Okay.
Yeah.
Understood.
Okay.
And if I may, I think our expert is available August 24th, September. I know that's a little outside. I'm Christopher Nichols set tomorrow.
Yeah.
Judge, that's a Monday.
That's okay. It's all right.
Okay.
Hey, well, wait a second. So we would pick on a Monday with, we start on the Tuesday, so we'd need them on the 25th.
Not a problem.
Yeah?
That works for us.
Okay, do it.
I will contact the experts if something wasn't.
So let's do this. Keep it on for tomorrow. You're not up. I'm not gonna let you, just, can you, I guess, make sure that they're okay, and then tomorrow we'll.
Can my client's appearance be?
Yeah, yeah.
All right, thank you very much, Judge.
Of course.
Thank you very much.
Justin.
I'm waiting for Dave.
Hey, you ready?
Generously sacrificing this.
You're a gentleman in a skull.
I am here on tomorrow's case that we were gonna have set for trial. I didn't know y'all had one today.
Yeah.
My gentleman is in custody. I did file a motion for speedy trial. I just kind of wanted that on the record to preserve that, but also, I also filed a motion for second chair as well.
I'll grant it.
Okay.
I'm okay with it.
It's already in queue, Judge.
Yeah, I'll sign it for
I
you.
split it up between two attorneys. It's at 6.
That's too much. One attorney's fine.
Just one.
Just one. I mean, if two, three lawyers, that's too much. One is
I
okay.
don't need to scratch out a name.
Yeah.
Or if you leave my brother's name on there.
Okay.
And scratch out
I'll
some
scratch off the
erasure.
other one. Yeah, you might. Yep.
We'll keep it a little.
And how am I gonna tell you two if, you know? I don't know who I'm gonna be talking to. Someone needs to put on glasses or, oh, the key.
And I'll probably wear my glasses.
Okay. You pick. I don't.
But, no, I was just, we're kind of feeling to the last try at working at.
I'm not, no. I'm not the time, no. I think that following that recommendation is, you know? Dave, Chief Dave. Okay. Thanks.
Right now, and this is like 5 of them, just for one person.
What was the recommendation for the dude? For Mr. Leonard's case? That's it. If he wants to do setup, then great. Otherwise, then we're going to trial. It's just too much. I'm next. I don't care. You pick. Well, I mean, within 30 days, within 30 days, unless you waive notice, you know.
No, we'd like to have it as soon as possible. Reserve for speedy trial.
Yeah, then you pick it.
Okay.
But within 30 days, I mean,
Any day of the week?
Tuesday usually, but you pick. I don't care.
Judge, just a heads up, we have 2 days and you're all not.
Okay, let me do this because Joe's been waiting for literally five years now. Hey, Joe, this is Mr. Zapeta. Is this Zapeta?
Yes.
Thank you for being patient, Joe.
Oh, quite all right.
You are Mr. Zapeta Bats?
Yes.
Mr. Zapeta Bats, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor. You are facing up to a year in jail and/or a $4,000 fine. You have worked out an agreement. They're offering you 20 days in jail with credit for the 9 days that you have done. By entering into this agreement, you are pleading guilty. This charge will go on your record. The DWI will go on your record. From now on, you will be facing a minimum of 90 days in jail should you pick up any more. Do you understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal.
Yes.
Is this what you want to do?
Yes, sir.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I will follow this agreement, sentence you to it. I am going to suspend your license for 180 days. Do not drive until you get a license, and good luck to you, sir. We'll roll the courthouse.
Thank you, Your Honor.
Okay, thank you for, again, being patient. Bye, Joe. Hi, Mr. Rodriguez?
Yes.
Good morning, Mr. Rodriguez. So you're charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 11 that you have done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. If you are on probation or parole at this time, pleading guilty to this offense may result in further incarceration. You understand?
Yes, Your Honor.
Is this what you want to do?
Yes.
From now on, you need to understand any more Class A misdemeanors in here, you'll be facing a minimum of 90 days in jail. Also, if you pick up any more evading arrest cases, this can be used to enhance your punishment to a potential felony next time. Knowing all this, you want to do this.
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Follow it. Good luck to you, sir.
Thank you, sir.
Thanks. Thank you, Ms. Henry. Hi,
Your Honor, may I vote?
please.
Mr. Bowman, I'm here on behalf of the fugitive case.
Hold on.
Wait for day, I can't do it without me.
Sorry.
It's on its way.
Give us 2 minutes. He's on the way and then we can pick it up. Sorry. Yes,
May I be excused?
please. Don't go far.
Oh, no, I won't.
I'm ready when you are. Hey, I have to give you a cause number. Are you-
The stage is a record.
Yeah.
2593071. Judge, you had posted a new bond.
Do you see it? You got it? Okay. All right. Good morning, Mr. Liu. So you speak English, sir? You're charged with, I have to make sure that everybody speaks. I don't know. I've never met you before. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On 9/8/2025, officer in his county business responded to a major accident at an apartment complex. Call notes indicated a motor vehicle collided into leasing office of complex. Upon arrival, officer flagged down by the witnesses, who stated the operator of the motor vehicle had fled the scene. Defendant located and, the defendant was located and detained. Witness advised, that she observed the motor vehicle to have collided with leasing office and defendant operator, seated in the driver's seat, exited, stumbling. Witness advised defendant, tried to reverse out of the leasing office, but defendant stumbled and fell into a flower bed. Officer observed the defendant to have a strong odor of alcoholic beverage, glassy eyes, glassy watery eyes, slurred speech. Defendant advised he had 2 shots. Defendant refused SFSCs and DIC was read. Blood warrant was executed. The result was 0.129.
Got it. All right, sir, I'm going to find that there's probable cause to go forward with your case. Does he have any priority to be licensed? Does he have a license?
No, Judge. No priors.
Mr. Liu, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Stop. You have the right to remain silent. Now it's just not the time. We will give you an opportunity to go hire a lawyer. You need to hire a lawyer. Any and all questions you may have, ask the lawyer and they can properly advise you on how to go forward. As it stands now, we're going to have you sign a reset. I'm going to have you sign bond conditions. At that point, we will give you a new court date. When you come, please come on the court date that we give you. And then at that time, when you do, please have a lawyer, okay? Please. Just, what's the question?
I just need to release the fundamental,
That's why you can't.
When are you going and where?
next week, on the law, or so it's long in advance, and so therefore I just want to see if I can travel.
So let's do this. Try to hire a lawyer, okay? And then see if they can come in before your trip. I don't want to start talking to you about things and, you know, you need a lawyer. So we will give you time. Don't miss court. Oh, also, Mr. Lee, you have already missed court once. Do not miss court again. Please. This is Mr. Shelton. All right, good morning, Mr. Shelton. Sir, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 27 days in jail with credit for the 9 days that you've done. This charge will go on your record. It will be there forever. You need to understand that from now on, it's at least a minimum of 30 days should you pick up any more cases. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. I don't know if you're on probation or parole. If you are, pleading guilty to this offense may result in the revocation of that probation or parole, resulting in further confinement. Do you understand? Is this what you want to do? It looks like he's also charged with driving while intoxicated.
Yes.
On that one, you're facing up to 6 months in jail and or a $2,000 fine. How do you plead to both cases, guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I will send you to it. I am going to suspend your license for 180 days. Do not drive until you get a license, and good luck to you, sir. Thanks. We'll roll at CC. How many do we have? Okay, bring one up.
Kara, top of 12.
Mr. Garrett, do you have a lawyer today?
No, sir, I'm a lawyer, and the way from asking possibly on.
Yeah, stop. We will give you more time. Head on over there. We'll give you a reset.
Bottom of 13, Johnson.
Sir, do you have a lawyer today? Tell me what you're doing about that. You need more time. Everybody wants a free, you know what I mean? How do you support yourself, sir? What do you do for a living? Okay, and what kind of money do you make a month? Okay, you can hire a lawyer. Just because you don't want to pay for a lawyer, you make $5,000 a month, dude. No, it's for people who are indigent. You understand? All right, we'll give you a reset. When you come back, please have a lawyer.
Jones. Page 27, come on up.
You said what page? You were Mr. Stokes. Mr. Stokes, do you have a lawyer today? Do you have a lawyer today?
No, I'll explain that when I'm sure.
No. We don't. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're just going to try to use it to prove guilt. You need a lawyer to represent you, and that person can help you navigate through this thing.
Yes, sir.
You understand? Okay. So, oh God, this case is old. All right, we are going to give you another reset. We will have you step on over there. When you come back, please have a lawyer. Come on. Okay, hey, are you ready?
Yes, Your Honor.
Let's roll.
Good morning.
It's mine.
Good afternoon, Your Honor.
Ms. Longman.
Oh, you remember my name? I must have made it.
Tell me, what's the last name?
Brittany Hubbard.
Hubbard.
Your Honor. This is a fugitive case, Your Honor.
Ouch. So she's on bond for suspended license and then she picked up another damn case.
No, Your Honor.
Okay,
That's not how.
Tell me.
But I know where you're about to go. So, Your Honor, Miss Hubbard, was a DWI. We were at the point of completion. She does not owe anything on her license but $25, money order, and she has to appear in person. We have that arranged with the sheriff's office in Ascension Parish. However, while she was in custody, I was notified by Ms. Anna, I believe, last week of her being a fugitive out in Louisiana. Okay, my client apparently waived.
hey, we're good. If you're waiting on us, go. We're done. Just, yeah, I don't know if any of you guys are waiting on us, but you're good to go. Yeah.
But she waived it, right? However, I believe like a day later, this new case was filed while she was in custody. So she was under the impression, we had a pickup date and everything. She was under the impression that she was gonna be picked up. This new case was filed. And now, I believe the clock has restarted for her. I'm asking for a fugitive bond, one, to resolve the BWLI because Ascension Parish needs her in person at the sheriff's office. I know you guys can transport her there, but that will probably be maybe within a week or 2 weeks. I already have arrangements with her mother and or her girlfriend to get her there. In regards to this theft here in Harris County, I believe there is discovery now, but that's something we can definitely work out with this court, even if she is.
But how does she pick up a theft if she's been in jail
It
since?
was a 2B, I believe, Your Honor. I don't, she didn't commit the.
But it says,
The filing date was June 25th, but the offense date is May 20th. So it was afterwards, a detective called in and made it later. So what happened was she did waive on the 19th. About a week later, they filed the 2B because they likely called intake during daytime and then filed a 2B warrant. And so that superseded the extradition. And so originally they were gonna pick her up a couple days out.
Damn.
And
Right.
It happens from time to time.
I know.
And I've explained to counsel, like, I don't believe she is a safety risk. I'm not even gonna try to claim that, but I do believe she's a flight risk. This isn't her first fugitive case. It is a relatively low level offense. She just doesn't do what the court tells her to do. So she's been a fugitive before and this is an FTA. So technically, there are 3 times she told the judge she was going to do something and then she.
Have I given her a bond before?
No, because she waived on the first setting. Right.
No, but with you said she had a prior fugitive case.
No, in Louisiana. She was a fugitive in Louisiana.
Same case?
I don't know, Judge, because that one's further back, so I don't know. But I can, hold on, let me look it up right now. So that fugitive case was in 2025, in Staten Rouge. So like I said, I don't believe she's a safety risk. I just don't think she's gonna go back, so.
Well, 1 year, she does have residence here, her partner is here, she's establishing a life here, she has a job.
Yeah, but she don't do what she said she's gonna do.
She was fine with me, Your Honor, here, and she's in court 14, Judge Fleischer will issue a warrant. That is no question.
I'm sure it had a warrant and then she didn't go back.
Well, she still even, she hadn't made bond on
And
that.
I made that. But-
No, she was out of.
No, he's saying that.
No.
She hasn't made the bond on theft yet, and we talked about that, and apparently she can, she just hasn't, so it's told either way.
What I'm saying is, I met her while, we've been in communication, I've consulted with her family.
Hey, can you bring up Miss Hubbard, please?
I think she's off. Oh, I should have asked if I needed to. She might. She was.
They sent her back.
Oh,
That's not good.
okay. Do you want to roll it over for, wait, hold on, what's the? I think it is. I mean, you said someone else was able to take her back if Judge Fleischer.
Yes, girlfriend is here, well, part of it is here, with her here.
I'm okay with it. I mean, it's, what does she want it for even?
Just want it for Larson, hold on, I want to check what level Larson is.
It's like,
1.5K, and they requested no bond just because of the appearance part of it.
Sure.
and I contacted Louisiana.
I'll set you a bond. I don't know how much. You guys see if there's something you can agree on.
Probably, I mean, like I said, the risk part of it, well, I don't want to do it on the fly, but.
No, but look, we have until tomorrow, right? Let's roll it to tomorrow. I'll set you a bond tomorrow. If you guys can agree on something, agree, and then, you know,
Ultimately, is she gonna make the bond tonight for the court 14 case?
they probably won't let her because of the fugitive case.
No, because she bonded on the other one, so she bonded on the DWI, so that's what it means, like, they said it already.
But that was before she picked up the fugitive case.
No, I understand, but that one, hold on, part of it.
A lot of times, because you have an open fugitive case, they see a bond denied, they won't let you set, a bonding company will not take the money because they know it's an exercise in futility, so they'll say, no, I'm not gonna take it.
It's more difficult, it's just not.
Yeah, sure, right, but, so I just don't want you to waste your time.
Fair enough, yeah.
Because why not post them both at the same time if you're gonna post it, you know?
Because if it turns out they don't do it for the 14, then she's getting held for 90 days on fugitive case while she's certainly here for 14. So knowing that.
Yeah, I'll commit to tomorrow, let's get her body to here tomorrow. If you guys can agree on something, great, if not, then we'll address it.
Thank you.
Stand under.
Yeah. Yes, thanks, Ms. Long. Okay, guys, you ready?
I need to clarify something with David, yes.
Okay.
Can we do it in front of you?
Take your time, no, take your time.
Yeah. I know the release is going to be today, it could be in 2 hours, it could be in 7 hours. Because he's literally, I call him done, this type of stuff. So that's the main.
Can you what? Yeah, for sure. What's the cost number?
That's true. Yeah.
You're thinking you can have at least over.
Oh, I'm sorry, they only give you the spin number.
Okay, yeah, that's all right.
And he said today, and I mean.
So 0323
Yeah.
on Shine.
Yeah.
It will be today.
He had been tested 40 days, from his arraignment, because of the date, that was based on.
No, because of my.
So let's do Monday.
Do you want to come in and sign the numbers?
No, but, well, somehow we got to get him to commit that he knows. So perhaps if you guys want to send him an email where he can reply, so we have a, you know, we know that he actually received it, so he can't claim, oh, I didn't know.
This morning, and so I'll see if I can talk to him.
Yeah, okay, or someone else, doesn't have to be you, someone. Yeah, okay, thanks.
Have the case review.
Yeah, for sure.
You're not gonna be happy about this.
Tell me.
It's Mr. Watson.
Debbie Watson? What's the last?
Got two new cases.
What's the last name?
255.
Okay.
0326. They're gonna stop and give explanation of possession of the vehicle. It's gotta be on our document. You still have those spellings in the.
Follow motion. Hey, you want to go to the list?
Do you have a lot?
No, stop them.
Bottom of one. What? Zipper SFBF,
5001. Hold on, hold on. Okay, 5,001.
Bottom of 14, set for arraignment, fails to appear.
2501.
Top of 15, set for CHA, fails to appear.
2501.
Top of 16, set for arraignment, fails to appear.
2501.
Bottom of 22, set for CHA, fails to appear.
2501.
Top of 28, set for arraignment, fails to appear.
2501.
Bottom of 30, set for arraignment, fails to appear.
She goes, oh, what?
Bottom of 30, you say? 2501.
Yes, you do.
Hey, guys, we're done. You guys want to talk? We're done. Okay.
That's, yeah.
Oh, God, there's a lot of stuff.
Well, technically you do it later.
Nine. Yeah. For Miss Jones, right?
So, yeah, some fourteen comes from, and then once it, and that's why.
Oh.
When the bear is doing it. It's up to them. Actually, no, it wouldn't do it. It wouldn't be the same on days. So if you wait long enough, then it.
Yeah, because we both.
And then see if it wakes them, if they're starting to. Okay, so yeah, because I don't know if you see if I'm doing it, Harris County alone. I would be very surprised. You know, a lot of history. That's just the one area. No, I mean, all of them. No, I mean. Oh, no, I see. Yeah. Oh, okay. I didn't know. That's why, that's why I. No, Jack is. Yeah, I just think that's like this. I just kind of like. Yeah, exactly. All the shit go back. Okay.
It's the very bottom. Very bottom.
What? Oh.
Oh, okay.
Right there?
Yeah.
I mean, it's still just say, the.
Hey, Jones took off without anything. Top of 14,
Yes.
so 5,001. Hey, guys, are you guys good? We're good? Justin, you good?
Yes, Judge.
Okay. We are done.